Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you. Thank you, Gio. Good morning. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my left is Judge Brennan. To my right is Judge Hershfang. And we will be your panel for all 6 cases this morning. I suspect that we'll hear 3 cases and then take a short break, and then we'll hear the remaining 3 cases for the day, if you want to plan accordingly. We should have enough seats for everybody to have a seat. See some familiar faces and some not so familiar faces. As you know that, well, let me first say, we've read the cases, we're familiar with the law, and so you need not do a deep dive into the facts. But of course, your 15 minutes is yours to use as you see fit. There is no rebuttal. And so it might make sense to get right to the argument. Some of these cases are fairly dense this morning. With that said, we'll call our first case. 25P0466, JANEY Construction Management and Consulting versus Charlie Rose Whitmore, GUSCOTT, and others.
Good morning, Your Honors. Joseph B. Lichtblau representing the appellant, JANEY Construction Management and Consulting, Inc. I'd like to begin with the JANEY's dismissed quantum merit claim. Your Honors, even under the old standard, pre-G4S, before the decision in the G4S case, JANEY would likely have been found to have acted in good faith. And of course, the older standard was harsher on builders. First, the house was substantially complete. The defendant actually admitted that.
Can I just start with your good faith argument? What does a jury's advisory verdict and then the judge's judgment on the 93A say about that as to the good faith as opposed to bad faith?
In
other words, I'm trying to understand how it's likely that you would have had good faith when both the jury and the judge appear to have found bad faith.
Well, what the jury and the judge found were 93A violations, but you know, the standard for good faith, even the old standard, was substantially complete, no intentional deviation from plans, and endeavored in good faith to complete the job. Of course, under the G4S, the standard is more of a holistic or totality of the circumstances. In G4S, the court said, you know, in G4S, of course, the breach approached criminality. And even then, the court said, you know, even an intentional breach, you still have to do the equitable weighing. So I think the fact that JANEY was found liable under 93A does not automatically mean bad faith.
Can I just clarify one thing? My understanding is that there are 2 different requirements, one being substantial performance and the other being a good faith effort to complete.
Yes, yes.
Okay.
Okay, yes. So what I was saying was that under the old standard before G4S, first, the building was substantially complete. They admitted that. Second, there's never been a claim that JANEY intentionally deviated. And third, as far as endeavored in good faith to complete the job, the circumstances that JANEY found itself in July of 2019 there were discussions going on with Ms. GUSCOTT, and then she suddenly died. So now Janey is left dealing with a stranger and scrambling because there's very little time, you know, under lien law to bring a suit and put the lien on. So I think a judge could find, a trial judge weighing the equities could find, even under the old standard, that Janey was acting in good faith. Of course, if
Weighing the equities, I'm not sure that that's the route to take. How far along was Janey in the project when GUSCOTT died?
when Ms. GUSCOTT died, it was complete. It was she had the certificate of occupancy had been issued in June 11th of 2019. I think she died July 22 of 2019. So the house was substantially complete. It had a certificate of occupancy.
So what were you just explaining was the impact on him when she died? What was the issue?
Well, I was explaining that in terms of endeavoring in good faith to complete the job, here they are discussing payment and whatnot. Then she suddenly dies overseas.
But your position is the job was complete
Yes.
when she died.
Well, there were punch lists. I'm sorry. There was a punch list. There was a punch list.
How does the judge's finding that the work was defective and incomplete factor into our analysis of whether the job was substantially complete?
Well, the job was substantially complete. I mean, first, the defendant's own expert admitted it, because under the contract, once the certificate of occupancy issued, that was substantial completion. So, you know, every job has a punch list. I mean, there's going to be work that's not done. There's going to be a cabinet not finished, this not done, that not done. But it's still, you know, it's $1 million house, so it's still substantially complete in terms of weighing that against what's been left undone.
I want to go back to G4S for a minute, because the way you're talking about it is not really consistent with my reading of what the SJC did in that case. You're talking about it as if it changed the law. I read it as affirming the law in the mine run of cases, right? So Justice Kafka wrote, "We conclude that complete and strict performance is still required for all construction contract terms relating to the design and construction itself." And then went on to do the new thing. "We also conclude, however, that ordinary contract principles, including the materiality rule, apply for breaches of other provisions, such as the one at issue governing payment certifications." Was the breach in this case something involving payment certifications or a similar thing?
The breach by the defendants or Janey's?
Janey's. Now we're talking about your quantum Merowit claim, so that's the relevant breach.
Right. So the breach that Janey sued for was non-payment of $133,000 or so.
And at that point, it's your contention that the evidence before the jury would show complete and strict performance of all construction contract terms relating to the design and construction?
I would say so, yes. I mean, the cases have allowed, as long as you're endeavoring in good faith to complete the job, to do the last, you know, whatever has to be done, then yes.
Right, I think there's a distinction here factually between sort of the punch list items, which I think are, you know, everybody has run into that if they've done any construction or renovation, and the kind of defects that were put forward to the jury and cited by the judge in terms of, you know, the new water damage and incomplete insulation and, you know, the electrical, I mean, I could go on and on, but do you agree that those are kind of two different buckets when you're thinking about good faith performance?
What are two different buckets? I'm not sure I understood.
The punch list stuff, so like this cabinet has no door, you know, this bathroom needs painting, and so on, versus you installed a toilet wrong and now there's water damage all underneath it.
Even their own architect called it a punch list. I mean, when it issued, it was a 32-point punch list is what he called it. And as I said, the house had a certificate of occupancy. It was being occupied. So I would say this was more or less, you know, given the size of this house, this was more or less a common punch list. So yes, I think that Janey could show strict compliance with the...
Didn't GUSCOTT have to stay in a hotel for a while?
Pardon me?
Didn't GUSCOTT have to stay in a hotel for a while?
Yes, Ms. GUSCOTT was out of the house from the time it burned down until about May of 2019. She was either in hotels or staying with her sister.
And why did she have to stay in the hotel? I see that you didn't really contest the expenses that they were attributing to the hotel.
Well, the expenses that they attributed to the hotel were only, I think, about $1,200, but she had to stay in a hotel because the house wasn't ready yet. They were still rebuilding the house.
And so to suggest that you had to pay for those expenses seems to admit it should have been ready.
Well, the expenses, as I said, there was only one hotel bill for just a few days it came out to about $1,200. That's the only hotel bill that was ever put into evidence.
That's not the point, though.
Yeah.
The point is she was displaced for that time, and you own it. So that seems to me that it wasn't ready when you contracted.
Well, I mean, there's no dispute that the house there was delay. You know, the house was supposed to be finished by, I think, March of 2018, and it got pushed into 2019 because of payment issues from the estate, you know, from Ms. GUSCOTT. Well, she wasn't the estate then, she was still alive, but she was way, way behind in payment, and by the summer of 2018, Janey had to leave the job and didn't come back or remobilize until January of 2019.
Did Janey ever claim entitlement, equitable entitlement, I should say, to partial payment?
Equitable entitlement to...
There's some partial payment, as opposed to the contract price. Because the way I read it, his complaint and the theme throughout was that on the quantum merit, he was saying he was equitably entitled to the entire contract price.
Well, that's how it was pleaded. I think that's how it's
Right,
commonly pleaded. And then Janey didn't get a chance to do much with the
But so if
quantum.
that's the case,
Yeah.
then if the jury says, okay, breach of contract, but no damages, doesn't that answer the question as to whether he's equitably entitled to anything? And if so, what's the prejudice?
Well, so the no damages, that argument, I think what it ignores is the difference between a breach of contract claim and a quantum merit claim in terms of how they proceed, in terms of evidence in a court. You know, in a quantum merit, you're sort of showing the value added, which would have made a huge difference here because Janey's last bill was from August of 2018, and then it's suing on you know, all I could do was point to this number in a lump sum contract. It would have been quite different had Janey been able to show this is the value added after we remobilized.
Or on a quantum merit, at least I'm entitled to this part of it, even if I'm not entitled to the whole thing. But he never really said that.
Well, you know, that would have been, certainly would have been the claim, but the claim was dismissed before it, you know.
When you say would have been the claim, it seems to me the claim was the claim, which is the complaint.
I think that is ordinarily how it's pleaded, that, you know, you're entitled to the full amount, and then what you prove at trial is what you prove at trial. Okay. Just, well, very briefly, I wanted to point out that, so the estate argues that Janey was not held to a strict compliance standard, and therefore the loss of the quantum merit claim makes no difference, to which I would say, number one, the courts have never said that being held to a strict compliance standard is the sum total reason that builders are allowed to bring quantum merit claims. And in fact, in G4S, the court, the SJC, as Your Honor pointed out, held that the non-building parts of these contracts are now subject to a materiality standard. So going forward, more builders would not be held to a strict compliance standard, and yet the SJC also relaxed the quantum merit rule. If I may, just turn very briefly to the FARDY decision. The appellee and the appellant seem to be reading the judge's 93A decision differently. I read it, I took the judge at face value. She said, I'm affirming what the jury did, so I took that to mean that she was upholding the jury's finding of, this act and this damage, this act and this damage. My sister says otherwise and says, well, it's just a lump sum. It's just $103,250. And if that's the case, that actually makes things easier, because there's only two baskets in which damages can fall, and they are either those credits, that $40,000 in credits, or the DePisa testimony. And so everything DePisa testified to would be subtracted under FARDY. So if the $40,000 in credits was not incomplete work or defective work, okay, fine, that's $40,000. That leaves almost $60,000 that would be subtracted under my sister's reading of the 93A decision. I think I'm down to the last seconds, so
I think you're right.
thank you.
Thank you. Attorney Goodhart.
Good morning. May it please the court. I represent the estate, and before I jump into the details of the G4S rule and the issues of law, I'd like to just take a moment to unpack what it means to represent the estate. I was originally retained by Valerie Whitmore GUSCOTT after she lost her husband and her father in the tragic house fire in March of 2017. She died on July 22nd, 2019, with the project not substantially complete. We do not admit that. We disputed that, and the judge found on an ample record that the project was not complete and that the work was defective. JANEY then sued Valerie and Ken GUSCOTT's 3 children, their twin daughters, Randy, Louise, and Charlie Rose, and their son, Kenneth, who were 21 and 20 years old at the time and still in school, as the heirs of their mother's estate, and also sued Valerie's sister and business partner, Wanda Whitmore, who, contrary to what my brother says, was not a stranger to this project, but had been engaged all along by her sister's side in dealing with JANEY and trying to deal with the accounting issues.
JANEY became involved in the project because he had had some affiliation with the family prior to the fire?
Let me say a word about that. Ken GUSCOTT was a revered, prominent real estate developer in Boston. He gave JANEY his professional start, as Mr. JANEY himself testified. JANEY considered and told the jury that Ken GUSCOTT was his mentor. And as a result, after the house fire, JANEY approached the widow, Valerie, and asked for the honor of rebuilding the house, promising to take good care of her and to do the project extremely well as his honor and tribute to his late mentor. He did not fulfill that promise. This is an equitable consideration apart from the strict terms of the statute, but I think it's important because it highlights just how badly JANEY deviated from what he set out to do. And the judge made specific findings that he did not pay attention to the project. He delegated it to others. He was not there. And in terms of the causes for delay along the way, the record shows, and the judge found, the contrary to what my brother said, the delay was not entirely attributable to Liberty Mutual being slow with the payments of the fire insurance proceeds that were to cover the costs of JANEY. Troy DePisa, the architect, testified, and the judge found that there was substantial delay for which JANEY was responsible. And Mr. DePisa knew that. That wasn't just a speculative assumption. He was there at the project, at all of the weekly meetings, time after time, when subcontractors who needed to be present did not show up. That's on JANEY, he testified, as the project manager. So we come to this case and to look at the rules of law that apply. Keep in mind, this is not a dispute like G4S that involves an 8-figure industrial construction project between sophisticated parties. There was no critical path methodology used here. The surviving members of the GUSCOTT family had no army of construction professionals on their payroll and readily available to offer opinion testimony. There was no opportunity for elaborate forensic investigations. This was a single-family home construction project paid for with fire insurance proceeds. And when we think about the procedural history of this case, what happened was the suit was brought close on the heels of the death of Valerie. The estate had to litigate this case, which it tried valiantly to settle and wasn't able to do, and that's in the record, had to prepare this case on a shoestring budget. We did no discovery. We did not go out and hire an extensive team of experts to present the case because the proportion, the perspective, the scope, and the resources didn't justify that. We relied on one expert.
What was the original contract price?
The original contract price all in is $1,043,000 approximately, and I know the document is hard to read. Of that original contract price, I think you can read the addendum that specifies the amount that Valerie was responsible for. That was in the, bear with me, I'll just grab my notes on that.
Is this at RA 43? I think it's the black and white version.
I think that's right. And she was personally responsible for $892,995. And by the way, that number wasn't plucked out of thin air. That was the number she felt comfortable and confident that she could personally commit to because that was the amount Liberty Mutual had already said it would pay. She didn't have money in her own pocket to pay. But JANEY sought the difference between the total contract sum of the $1,043,000 minus the amount it had received. And this is in evidence and undisputed. It's Exhibits 8H and Exhibit 25 and cited by the judge, I believe. JANEY was paid $981,018.24 for an incomplete and defective project. JANEY wants to collect the balance with a mere $15,500 adjustment, but it's measuring its claimed damages by the original contract price. And it is customary in a construction case at the outset for a plaintiff to plead in the alternative, a contract claim and a quantum merit claim. But when you get down to trial, these are generally alternative theories of recovery. You don't get to double dip. Either there is a valid and enforceable contract that covers the scope of what's being claimed, and I think there can be no dispute that there was in this case, or you may have an equitable opportunity to avoid an unjust windfall if a contract is unenforceable or doesn't cover the subject matter, to say as a matter of equity, it would be a total unfair situation to allow the contract, the person for whom the house is being built, to be enriched unjustly.
That's their argument.
That's their argument. And what I want to say to you is, at the pleading stage, they never articulated any different bucket of value that they added that wasn't covered by the contract. I did not move to dismiss the quantum merit claim at the pleading stage, even though we had a fully integrated signed contract that by their own claim covered the subject matter. I waited till the case was ready for trial, and in order to streamline the issues, at that point I moved. I think it was incumbent on plaintiff at that point, if not before, to come forward and say, here is the equitable case. Here's the expert that I'm going to show what value we conferred above and beyond the work we did and were paid for. There was no such claim articulated. It was only ever, no, I want my 133 balance of the contract price. So in the absence of any showing of a real, equitable, unjust enrichment claim, the trial judge properly relied on the very basic common law rule, you don't have both. If there's a valid contract, you go under the contract. She dismissed the quantum merit claim. That was vindicated at trial, and we know by the jury's verdict that there was a viable contract claim. Indeed, the jury found that Ms. GUSCOTT or the estate had breached the contract, but they found that there were no damages due. So where there's a valid contract and you go all the way to trial and you lose your contract claim, you don't get to come back, and we still don't know before this court on the record that's presented on the briefs. We have never heard what the unjust enrichment was. Again, there was no expert proffered. This is so different than G4S. In G4S, the contractor said, I'm entitled to a $10 million equitable adjustment. Maybe I didn't do what I was supposed to do on the payment certifications and paying contractors, but look, on this $45 million contract for a 1,200-mile fiber optic network for the Commonwealth, I have actually done work not covered by the contract that it would be a gross unjust enrichment to the state if I'm not paid what G4S said was a $10 million adjustment. So what the court did in G4S was it dealt first with the standard for contract law, and it addressed the old common law rule that you needed strict performance of all of the design and construction elements. It saved that, really. There was no major adjustment of the law, but it did go on to say that if you cannot succeed on a contract case because of the application of that rule, you may have a quantum merit claim if you can show some other damages. They could not. They never get to the G4S rule because this judge, if you look at the jury instructions, didn't give the harsh jury instructions that the G4S case said we're now going to relax. This case was tried by both sides on the same substantial performance standard that the SJC now says you follow in a construction case in G4S. So we get to the, so my position is we never get to quantum merit. They didn't plead it, they didn't articulate it, they still can't show it. All the relief they were ever seeking is covered by the contract. It rises and falls on their contract claim. They lost. It's over. But if you are to indulge their argument and get to the quantum merit claim, then you get to the issues that you were asking about, Justice Brennan. Did they substantially perform, and did they act in good faith? The answer to those questions, according to both the jury verdict and the judge's findings, are no and no. The judge found incomplete, defective performance, so they can't meet that prong. We don't even have to get to good faith. But if we do, I think it's impossible on this record and on the judge's findings to say that there is any possibility they could have demonstrated good faith. They were found liable for repeated false promises, for delay, for shoddy work. I mean, there's a whole litany of
False promises were just kind of stringing them along.
stringing them along. And you know, my brother says it's only a few days of a hotel. Let me be clear. The GUSCOTT family was out of their house for from the date of the fire in early March until May of 2019. And the reason she didn't have a much bigger hotel bill is because the fire insurance proceeds paid for a whole year of being out of her home. The project was supposed to be done well within that year. The project was supposed to be done within a few months. So after she's exhausted the insurance money, she goes to a hotel. Her sister's not charging her to sleep on the sofa. There's real damage because
The kids have to come and go from the hotel as well when they're home from college?
Right, and we're talking about young people, 20, 21.
Or I shouldn't say kids, but they're young adults.
They're young kids, in my book, Your Honor, as a parent.
Mine too,
And
if I'm being honest.
in school, getting served with a summons and complaint right before Christmas. This is a really tough case for JANEY to come in and say, on the equities here, there was unjust enrichment. So that's what I have to say about
Can you take a minute just to discuss the damages
Yes.
part, please?
Yes.
Thanks.
So on the damages, I think that JANEY is aiming at the wrong targets in two ways. One, the judge's findings were advisory. And I think the judge made clear enough, quite clear actually, and I think she made it extra clear in her various motions on the new trial and for reconsideration and to amend the judgment, that she considered the jury's findings. That's why she asked for their advisory findings, so she could consider them. But she made her own independent assessment. She owns her findings. She found, in terms of damages, and I will tell you that we think the record could have supported her choosing a higher number, but the record certainly sustains the numbers she did choose. She found that Troy DePisa and his testimony supported a finding of $83,000 in damage to the home. She added to that the $7,000 for the window repairs. And so if you take, you're at $90,000 there already. She awarded $103,000. Is there substantial proof in the record for that last $13,000 worth of damages? Certainly there is, and we've included in our brief a detailed recitation of all of the different items of economic damages that get you somewhere in the 30s or 40s. So the elements are there. But the second point that's really important is on appeal, it's not the job of this court to go through item by item by item.
Especially when you can't read it.
Especially when you can't read it and when the evidence was ambiguous and confusing. And I think that one of the things I will say about that is, to the extent the accounting is fuzzy, that's on JANEY. It was JANEY's job to provide precise accounting. So,
Goodhart, I see that your time.
thank you.
So I think we'll have to leave it
I'll
there.
rely on the briefs. Thank you, Your Honor.
That'll stand submitted. Thank you. I wasn't sure. Yeah, for sure. Well, at least on one side of it. Next up on our docket is 25P0847, REVVITY Signal Software Inc. versus Cloud Software Group.
Good morning, Your Honors, and may it please the Court, Derek Schaefer here on behalf of Appellant Cloud. Under Massachusetts law, Your Honors, the plain terms of the parties' contract control as a matter of law and should suffice to resolve the entire appeal in our submission. The Superior Court reached the result it did only by straying from those terms, as Your Honors will see upon comparing the Superior Court's ruling with the controlling contractual provisions. And note, Your Honors, that I needn't employ reductio ad absurdum to show Your Honors how wrong and perverse REVVITY's reading is. Under REVVITY's avowed, persisting position, as endorsed by the court below, it was perfectly within its rights to use its so-called order form method to have the royalties it paid Cloud just by Your Honors, combining 500 spot fire licenses with 5 REVVITY product licenses strategically on the same order form.
So that's getting into the bundling aspect is what you're referring to. But let's just go back a little bit further in time. And the beginning of the contract was when?
2012 was the first
And the
version of it.
dispute arose when?
The dispute, Your Honor, I think came to a head around 2023, 2024, but there were concerns by our side before then that the royalties coming back were not what they should be.
When did those concerns arise?
I think into the contract by a matter of years, Your Honor, because there was,
How many years?
I think it was over in a span of time, Your Honors. I don't know that the record tells us exactly when there were first those concerns.
What's your best guess as you stand there right now?
I think it was slow payment from the beginning, so I don't think it was long after the contract was entered. I think it was in the early going that the pace of the royalties was slower than anticipated.
When did they first complain?
I think that the first complaint, Your Honor, about, and certainly the need for an audit was coming around 2023.
So it's like
23, you said?
20 years.
Your Honors,
I mean, those are your numbers, right?
Justice Desmond, I'm trying to answer the question based on the record that I have. I don't want to go beyond that.
That's what we're trying to deal
I
with.
understand, Your Honor.
Okay.
But, so I think that the concern came to a head with the PricewaterhouseCoopers audit, and what I mean by that is PricewaterhouseCoopers came back saying that this order form method was being used so that document numbers were the touchstone for whether REVVITY was claiming the reduced royalty.
What prompted the audit?
The audit was concerns that the royalties were being underpaid relative to expectations and the exclusivity that REVVITY had as the other side of the contract.
Was there any change in the players?
Yes, Your Honors.
Okay. Did that coincide with the audit?
It did, Your Honors. It was after there was...
You're not telling me that part, so tell me that part.
Well, Your Honor, yes, it was after there was cloud coming into our side of the contract. But I don't think that matters to what the terms say, and I don't think it matters to the record that the court has based upon discovery. The first audit, I'd emphasize, Justice Desmond, the first audit was PricewaterhouseCoopers, and there were complaints from the other side that was too rigorous or skewed an audit. But before then, there had never been anyone going through the methodology for the royalties.
So,
I'm sorry,
go ahead. Going back to the beginning of the contract, this authority to have an independent audit, to go through the methodology, that is something for which Cloud's predecessor had bargained and had gotten in the contract.
That's correct, Justice Hershfang. And they
So
could do it
I'm
themselves.
still going. At any point from the beginning of the contract, your client's predecessor had the ability to do an independent audit.
Yes, that is true, and to do it themselves. It was either one. It could be they themselves or their chosen auditor.
And this was a pretty big piece of the business, especially back when it was back in the TIBCO days, right? By this, I mean this relationship with REVVITY's predecessor.
It was significant, yes, and there was exclusivity that attached. So that was quite a commitment on the part of our side of the contract.
And you mentioned earlier in response to one of Justice Desmond's questions that concerns had arisen. You don't know when because you don't want to go outside the record, but there had been concerns from long ago about how these royalties were being repaid.
Let me be clear about it, Justice Hershfang. I think it was the bottom line of how quickly our royalties coming back. There was disappointment about that, not about the methodology. There was not a discussion between Cloud and REVVITY, or even as far as the early record shows, about Cloud saying, we think REVVITY is gaming its approach to the reduced royalty. I have to tell you, Your Honors, that comes out of the PricewaterhouseCoopers audit, and that was not something that had been shared in any of the record exchanges that were relied upon by the Superior Court.
Did the audit come with some instructions when they were retained?
Yes, Justice Desmond, it did. But they were the same instructions that Cloud could have given itself had it been undertaking the audit pursuant to the bargain for right. And, Your Honors, under the after acquired evidence doctrine in Massachusetts, the record that determines whether there was a breach is what was produced during discovery. And the motivations of the parties, either way, don't really matter. I would submit to Your Honors that the bottom line that comes through is that REVVITY was using the order form method. And my additional submission is, based upon the terms of the contract, that just isn't kosher. And I'd like to go through those provisions if I could, Your Honors.
Can I ask you a question before you?
Yes, Justice
No,
Brennan,
no,
sorry.
No, go ahead.
I'm not sure if you're not done with that issue. It's slightly different.
I was just going to ask, there was a Chapter 93 claim?
There is.
All right, so do the motivations matter with respect to Chapter 93?
Yes, if you think that it was basically a bad faith breach of contract by Cloud, yes, you can get into that. I think if we're right about the contract that decides 93A, and if you think that there was a good faith dispute, at least in so much as Revvity was breaching the implied covenant of good faith and fair dealing, as we think comes through from the facts, it shouldn't be a 93A violation. And I'll talk more about that if I may, but I do want to focus on the plain terms. Sorry, Justice.
So so I'm trying to understand your definition of a bundled combination, and specifically whether different software can be combined or integrated into one product.
Okay. I think it could. That would be, yes, I think it can be, and it was, because there were actual bundled combinations that Revvity was selling. And I would say, Justice Brennan, if you think about a baseball pack, you might have a glove and a bat and a ball, and they're all in one package, a starter kit, and they're under one label and one name. Those don't necessarily combine other than for the game. We're not saying that that couldn't be a bundled combination, but that is very, very different from saying the flat screen TV is bundled with a pack of gum that the customer picks up at the register because they're both rung up together. It's the latter that Revvity treats as the bundled combination, and we submit that just can't be right. And the bundled combination definition in the SPCA, it's 1.3. It requires that the bundled products, after all, are combined with one another. And I'd submit, Your Honors, in this context, you wouldn't expect sophisticated parties to say that products are being bundled just because they're rung up at the cash register.
So I want to ask you a more precise question about that, and I apologize because I'm looking at the SCPA, but
No
I know
problem.
it's the same. I'm just,
It is.
what you're referring to now is a part of the agreements that is under the header branding and use of trade names, right?
I was actually referring to 1.3 in the SPCA, which I think is 1.2 in the SPA, definitional, starting with the definitions of bundled combination. But I'm glad to talk to you, Justice Hershfang, about 10.2.
Okay, great. My question for you, and maybe this is easy to answer, is if I don't buy the 10.2 argument,
Okay.
in other words, if I don't think that branding and use of trade name provisions should be read into a definition,
Okay?
can you still win?
Yes.
Okay.
Yes,
how-
I can, but I'd ask you not to completely disregard the provision. Let me move
Well,
away
I'm
from...
not disregarding things. I'm just exploring.
So the definition of partner solution is also there in SPCA 1.37. The equivalent in the SPA is 1.25. And that means a product offering, singular, that is created through the bundled combination. And so we would submit that if we're right that bundled combination is a subset of partner solution, and the contract is explicit about that, then we're talking about what's meant to be a single product offering, and it's got to be created through a bundled combination. I don't think it makes any sense to say that separately sold products that are sold standalone are creating any sort of a single product offering. And then there are the royalty provisions that combine with that too. That's where the money is, Your Honors, the royalty provisions. In the SPCA, it's 5.13. And let me read the first part of that. The royalty rate shall depend on whether Spotfire is licensed as part of a bundled combination or other partner solution, so explicitly treating the one as a subset of the other, or on a resale basis. So when Spotfire is just sold by Revvity, alongside some other Revvity product or even a Revvity service, which is part of what they were doing, that's just a resale of Spotfire. The bundled combination is when you do something different, when you've created a new product offering, singular, that's been created through the bundled combination.
And this is important because the royalties are different, right? If it's
They are one's half the other, Justice Desmond, so it makes all the difference.
And the record shows that from the outset, they were bundling them as you're complaining about right now.
I don't think it speaks to that, Justice Desmond. I don't think it tells us when this process began.
You were concerned about the royalties coming in slowly from, you said, almost the beginning of the contract.
Correct.
Did I hear you say that?
Yes, we don't know why that was. So I mean,
But you didn't elect to have an audit.
That's correct.
And so for 20 years, that was essentially the practice.
Well, it was the unknown, unspecified practice. I really can't tell you when they first initiated the order form method. The facts that were turned up during discovery were that, within, relatively recent proximity to the audit, this was being gamed by REVVITY in what I would call pretty egregious fashion, where you're taking just a little bit of REVVITY, even a renewal of a REVVITY service, and strategically putting that on an order form so that, voila, they get the reduced royalty. But if I may, Justice Hershfang, I now want to go back to Section 10.2, because this is also an agreement that says in 27.4, the headings don't matter, they don't control. So we're talking about what did the parties mean for a bundled combination to be. I think the definitions are clear about this for the reason I submitted. I think that the royalty provision makes clear that the bundled combination needs to be some form of a partner solution, and the partner solution is the single product offering. It has to be created through a bundled combination. But now they're saying again, here's what a bundled combination has to be and what has to be done. For a partner solution, which includes a bundled combination of the Spotfire platform, the platform must be licensed together with the partner product under a collective name such as XX bundle. That's a must-be provision, Your Honors. And what happens, I think, in the REVVITY interpretation, it's what you said, Justice Hershfang, you have to basically put 10.2 completely to the side. Because otherwise, their position is, yes, this is what they have to do for a bundled combination. It has to be licensed and packaged together, unless it's a different kind of bundled combination where you don't have to do any of that. They just wind up with the same order form. That, Your Honors, I don't think is correct. And the last point about the plain terms of the contract, it's also in SPCA 5.13, the royalty provision, after the chart. 40% royalty rate for partners' resale transactions. So when they're just reselling Spotfire, it's 40%, and 20% royalty rate for bundled combination or other partner solution transactions. So that's binary. It's, again, explicitly separating the mere resale of Spotfire. That's not REVVITY doing any work to create a new market, expand the market for Spotfire, just reselling it, the higher royalty. Or you got to do the work of a partner solution with everything we were talking about with 10.2, the bundled combination. You could have a partner solution through embedding. That's, I think, what you were getting to, Justice Brennan, if you had compatible software that was bundled. They didn't do that. There was no embedding. So the only rightful way for them to get to a partner solution on this record is through a bundled combination. And I just don't think it is a tenable interpretation of the contract to say that the order form method qualifies for that. I think it's an end run, Your Honors. And if I wasn't right about the plain terms of the contract, I think you would have the implied covenant of good faith and fair dealing. This is REVVITY going to tremendous lengths at its whim to deny Cloud the full royalty, and that's the record, Justice Desmond. I think that that stands apart from the history of this and the finger pointing. It's just the plain terms of the contract that I think lead to the right result here. It's undisputed that if we're right in our reading of those plain terms, REVVITY underpaid by $17.8 million. They were given a chance before the trial, November 2024. This is Cloud's notice of termination because everything that's come to light with the order form method says that you, REVVITY, are in breach. There's never been an apology. There's never been a correction. Their position before you today remains that they can do everything that this record reflects them doing. And the Superior Court's decision is not only green lights that, but says that our client has to continue performing its side of the bargain through 2034. And we think that that specific performance remedy goes too far, given the duration, given the discord between the parties, given the inequitable conduct by REVVITY that we've been talking about, and the fact that this is software, after all, just that. And then, Your Honors, there's also the 93A question. I didn't want to give...
I think the apology would have done it?
Well, Justice Desmond...
It's not too late.
I want to be clear. If they had said, we're going to drop the order form method, we recognize that that is not compatible with the contract, we would have had a commercial discussion at that point. At least that would have been our recommendation to our client. But what came back was what you've seen in this record. They think it's absolutely fine. They don't owe us a penny of the $17.8 million that results solely from use of the order form method, as opposed to any genuine bundling. That's the position that the case is in right now.
And is that the primary concern, or is it the specific performance?
Well, both are concerns, Justice Desmond. Both are concerns, but there's a lot that they get from exclusivity. We want to get the fair royalties. We wanted to be getting the fair royalties going back years, and I think that the number is north of $20 million that we think we've been underpaid. The last point, Your Honors, we rest in our briefing as to why the record does not reflect the conduct that violates 93A happening primarily and substantially in Massachusetts.
Judge Krupp had some pretty strong language regarding that, didn't he?
He does, but I don't think it's language that gets past the FTI decision of this court. I think that That holding on this record leads to the conclusion we submit that this was not happening primarily and substantially 93A. The work of the 93A violation was the contact with the customers, and that was happening outside of Massachusetts from decision makers outside of Massachusetts.
Thank you kindly.
Thank you, Your Honor.
Good morning, members of the panel. May it please the court. Eric Sandler for the appellee, REVVITY Signal Software. I'm joined by Lauren Peipenbacher. I'd like to start by assisting the court with some of the questions that were presented to counsel concerning when concerns with the royalty reporting arose and when they were raised with REVVITY. Counsel referred to REVVITY's position being a persistent position, and that's exactly right. That is what Judge Krupp found on a voluminous trial record, that REVVITY's reporting of sales of Spotfire with REVVITY products as bundled combinations was consistent from the beginning of the agreement. And even more so, there were findings that Cloud understood that reporting method was being used, that it had every incentive to call it out as incorrect if it was incorrect, and they never objected despite this coming up every step of the way. There was testimony from the early TIBCO executives who negotiated this agreement, that's Cloud's predecessor, that they inspected, this was Peter Lee who testified at trial, that he inspected the royalty reports and found them to be as he expected. And then there was testimony from REVVITY's Rob Woodard that in 2016, the Cloud individuals came to the Waltham offices of REVVITY to inspect those royalty reports and never raised an objection to them.
So does that mean that they're prohibited from raising the objections now?
They're not prohibited from making a contractual argument at this point, but the long course of performance here, as this court said in cases like the Talverde decision, is oftentimes the best way to know what the parties intended is to look at what they did. And here for a nearly 10-year periods, the royalties were consistently reported. And the last significant piece of evidence at trial on this issue was the testimony from REVVITY's Rob Woodard and Cloud's Juliet Githegi about an exchange they had in 2016 about this very issue. It's, if your honors want to check the record, Mr. Woodard's testimony on this is at volume 16, pages 190 to 193, where he went through painstakingly his emails to Ms. Githegi, the royalty report sent to her, how you could sort the royalty report by order and look at the Spotfire components, the REVVITY components, and see that the lower royalty rate is being applied when they're sold together.
Can you speak to the argument, and I may not have it exactly right, but if you stick a flat screen and a sandwich on the same invoice, doesn't make it a bundle combination?
Yeah, Your Honor, we are talking about products that are not consumer products, like flat screen TVs.
Which makes it a little bit more difficult to...
Or the stick of gum that you might buy as an impulse purchase on the way out when you're checking out. These are scientific software products that are used by life sciences companies and pharmaceutical companies for their long-term research projects. These are 10-year-plus projects. These are very deliberate purchases. And the entire purpose that Spotfire had in entering into these agreements with REVVITY was that they were attracted by the possibility of REVVITY being able to sell its existing products such as ChemDraw with Spotfire, and this would result in market penetration.
So you go to the market and then you just add one of your things, and then maybe someone who's on the other receiving it says, it's pretty good stuff, and that increases your saleability of
Well, the ability to cross-sell and have customers purchase, Spotfire when they're first interested in REVVITY was one of the purposes of the contract as found by the trial court. And there weren't any examples, at least not any credible examples that the trial judge credited that there was somehow any sort of manipulation by adding on certain products to achieve the lower royalty report. And the other thing I'll add, counsel makes the argument that on certain purchases there's more Spotfire licenses sold than the REVVITY products. And first I'll note that while they claim this is a textual legal argument about the contract, that's a very purpose-driven, look at the extrinsic evidence type argument. And the trial judge just completely rejected that based on the evidence of what the parties intended. Mr. Hattabo, Craig Hattabo, who was another TIBCO executive who negotiated these contracts, he testified live at trial. He was the co-lead on these agreements. He said it was totally normal, in his words, to see more spot fire licenses sold than the REVVITY products.
What's your take on the significance of 10.2?
It is strictly a branding provision applicable to partner solutions.
Doesn't inform in any way what a bundled combination is.
No, it doesn't, because it speaks to only how you brand partner solutions. It doesn't speak to how you brand a bundled combination. The only requirement under the plain language of the agreement for a bundled combination is that the spot fire platform be combined with a REVVITY product. And from a textual perspective, since that applies to both hardware and software products, there were findings by the trial judge that the only way to combine spot fire with a hardware product like a mass spectrometer or a popular REVVITY software product like ChemDraw was to sell them together. You can't combine the technology of those. And those were findings. There was no controverting evidence on that point.
But when you say to sell them together, I assume you're talking about a type of software or, a program from cloud that runs on the mass spectrometer, right? I mean, combine, I know this is a big point of dispute and I'm not making any statements of law here, but combine is kind of is a baggy, indefinite term, right? I can combine, ingredients and make salsa, or I can combine ingredients and make something disgusting and inedible. Are both of those combinations under the contract, in your view?
If they are sold together, yes. And to the extent that there's any uncertainty about those terms based on the arguments that Cloud is making, now, we're very confident that we are right on the plain language of the agreement and that Cloud's arguments were correctly, soundly rejected by the trial judge. But if there's any uncertainty about that, then the evidence of the party's purpose and the course of performance here is overwhelming based on the trial judge's findings that here the parties intended that when spot fire was sold with a REVVITY product on the same order, that REVVITY was entitled to the lower royalty rate, and that is because doing so achieved this objective that Cloud expressly had, that they wanted to see as much spot fire sold into the life sciences market as possible. An objective that they admittedly could not achieve on their own.
So your view of the economic benefit to spot fire, to Cloud, TIBCO, of entering into this agreement, assuming it was, to use counsel's model, the stick of gum with the flat screen TV is right, but then you're in the market with your flat screen TV and they're going to keep coming back to you. So the discount is reasonable, economically reasonable, because it incentivizes your client to sell more of their sticks of gum. Now I've totally mixed up the metaphor, but you know what I mean.
Precisely right, and to take the stick of gum word, as found by the trial judge, the market for spot fire is a very sticky market with high retention rates, more than 100% retention rate. So once the spot fire is out there, once it's pervasively used, as the trial court found, in the life sciences market, those customers are going to keep renewing. And that's an important factor.
That was a big part of what Judge Krupp was talking about, right?
Exactly.
The sticky market.
Exactly, which goes to the specific performance issue and Judge Krupp's findings on that. And I would like to just return to the issue of when were there concerns about the reporting from REVVITY? I'd ask the court.
When there was a changing of the guard?
When new private equity owners came in to own Cloud, there was a changing of the guard and definitely a change of approach. And if all you need to look at is one of their termination threats in June of 2023. It was Exhibit 16, Record Appendix 4, page 362. This was the letter sent to REVVITY's offices in Waltham, and explicitly said, without citing any breach, any concern about royalty reporting, or anything else, we are going to, in 30 days, cease performance and revoke all rights granted to REVVITY under the agreements, and the toll they tried to extract from REVVITY was for REVVITY to cede its rights to exclusivity, its rights to the duration of the contracts, and make other concessions to Cloud. And it wasn't until REVVITY didn't buckle to that threat that they shifted to, let's bring in PwC, let's dictate to them what this contract means, that they shifted their approach to trying to come up with some reason for breach, and they latched on to this bundled combination theory, which, by the way, the definition they gave to PwC is not the definition they pursued at trial, and it's not even the definition that they're pursuing here in the appeals court. This is not a genuine dispute over good faith interpretations of the agreement. Judge Krupp's findings in that respect were very clear that this was a willful breach designed to obtain unbargained for benefits at the expense of REVVITY.
Were the damages difficult to determine, and is that why Judge Krupp decided to go with the specific performance?
Yes, Judge Krupp, and this is a discretionary decision from the trial judge as to whether to avoid specific performance. He credited the testimony of REVVITY's expert that the damages are difficult to quantify with any reasonable certainty. He also considered the difficulty, and this is in the standard for specific performance, because the availability of damages is not a prohibition against specific performance. The court needs to consider, how difficult is it going to be for you to obtain a substitute if you're awarded money damages. And here, Judge Krupp made very specific findings, amply supported by the voluminous record here, that it would be extremely difficult and costly, if not impossible, to replace spot fire in this market. It is not an interchangeable software product like the generic, general network monitoring software in the ILAN versus NetScout case that Cloud relies upon. This is a very, it has extensibility that makes it unique for the life sciences market, and other qualities that it's been built into a lot of life science customers' research projects, ongoing research projects that would be impacted, and by extension, REVVITY's business would be impacted as well. So their challenge to the specific performance determination here, really, it's a factual challenge.
So that's an abuse of discretion on that one. I mean, on the contract, obviously, we have to look at it de novo, but you're saying on the specific performance, the judge's decision there, that's an abuse of discretion?
That's correct. Both parties agree in their briefs that it's an abuse of discretion standard. If I may use my remaining time to address their 93A argument, unless
Yeah, did it
the court
happen
has other questions.
substantially in Massachusetts?
Yes. Now, under the Kuwaiti-Danish decision, which Your Honors are well familiar with, it's a flexible standard unique to the facts of the case. But no matter what variation of the primarily substantially standard you consider here, this case checks all of the boxes. First, you have the victim of the unfair conduct here in Massachusetts. And we're not just talking about a Waltham address. We're talking about real people who run the REVVITY Signals business that had to deal with the what Judge Krupp described as a fire drill and fallout caused by Cloud's conduct. They had to deal with the termination threats that began in 2003. They had to deal with the sham audit, what was found to be a sham audit. Those were people right here in Massachusetts, as Judge Krupp explained in his decision. And then the fallout from the termination of services and the sales blitz on REVVITY's customers. It's the general manager of the Signals software business, the head of support of the Signals software business, other personnel, all trying to deal with that. That's happening all right here in Massachusetts. I mean, in substance, what they tried to do here was take a Massachusetts-based life sciences software business from a Massachusetts company. And then when you add to that their key person, the person who Judge Krupp found to have carried out the very conduct that was unfair, was based right here in Massachusetts. And they say, well, Terry Bonet, she was just a low-level employee. she was responsible for the REVVITY relationship in 2023. She was senior enterprise account executive for the entire North American market. She was one of 5 members of the life sciences task force that Cloud formed while they were doing this audit because they knew they had plans to go try to steal the business. And she also contacted many of those customers right here in Massachusetts, as you would expect with the Boston area being a life sciences hub. Many of those customers and Spotfire users are right here in Massachusetts. I see my time is up. If there's no questions, I'll rest on the brief.
Matter stands submitted. Thank you.
Thank you, Your Honors.
Give it a second to let things settle down in a couple of minutes.
Folks lost your audience. You lost your audience.
Don't take it personally.
Easements might not be as riveting.
Okay with me, Your Honor.
Next up on our docket, 25P0615, Willis A.M. Henley and another versus Adam DARISSE, I'm not quite sure how to pronounce that, and another. Attorney Meltzer?
Thank you, if I may, Your Honor. Good morning, and may it please the Court. My name is Robert Meltzer, and I'm here today on behalf of the appellants, Willis A.M. and Rubina Henley. Now, as the Court is aware, there are 2 major issues with this appeal, and I would like to discuss both of them today. The first being the interpretation of the deed granting the easements in question based upon the clear and unambiguous language of that deed, and the second issue being the encroaching underground utilities that are cutting through the Henley's land. Your Honor, if I may, with regard to the first issue, the interpretation of the deed that has granted these 2 easements in question, easement 1 and easement 2, we agree with the land court that the deed itself is clear and unambiguous. However, a plain reading of this deed shows that the scope of easement 1 is a general access scope. It's a general access easement, and we know this based upon the reading of this deed, especially relative to the plain language that we see for easement 2.
So that was not in the plaintiff's complaint. Is that fair?
That was not directly addressed in the complaint. I understand that that was an issue raised in the appellee's brief. However, we, in our reply, did respond to that, Your Honor, and essentially what we have here is that Rule 15 does cover the issue in question. Rule 15b specifically outlines, as I'm sure the Court is aware, that issues that were not initially pleaded can still be tried by express or implied consent. And this is a situation where there was implied consent to try the issue. Certainly, matters can evolve from the time the initial filing of a complaint.
Can I just stop you for a moment on that? Because again,
Yes.
my read of the record was that the defendants repeatedly argued that the issue wasn't properly before the trial court. Am I wrong on that? So how's that? I mean, just because
Yes.
the judge said, or the too bad, how is that implied consent?
There were objections, which I would say were not very strong, more casual objections. They were not primarily made before trial in any sort of strong footing. They were made during post-trial brief, motion for directed verdict, and closing arguments after the fact.
Okay.
I think what we have here is when we look at the entire scope of the record, we have an issue that was clearly articulated and outlined for both parties and for the trial court months before the trial even occurred. There was a very substantial joint pretrial memorandum that was filed with legal arguments made by both sides in this joint pretrial memorandum. And the number one issue that was addressed in that joint pretrial memo is this exact issue in question, Your Honor, which was, what is the scope of easement 1? Is it a general access easement? This is a situation where even the prayer for relief, which, as we know from the certificate of service, the prayer for relief at trial, one of the issues that was served on day one also was the scope of easement. So this was not a surprise issue that was dropped upon the appellees, the defendants in this case. It was not an issue that could not have been predicted. And I think more importantly, there's no argument by the appellees that they were actually prejudiced by the fact that this was going to be an issue tried at trial. This is not a circumstance where they did not have ample time to understand and brief their opposition or to prepare their strategy accordingly. There are two cases, I believe, that were cited in our reply brief that address this issue. And I think this is more in line with the case of Jensen v. Daniels, which was a case out of this court from 2003, which said that the record meets the test for implied consent of the unpleaded issue, where the parties were fully aware. It's very different than a different case, Ahmed versus Fadali from the SJC, which was where a completely new claim or completely new theory of the case came up after the trial and after the evidence had closed. And I would note, I think it is significant that this was not an issue that was even addressed by the land court, by the judge in his decision. It was a matter where he fully understood the arguments, he had accepted all of the evidence, and then he fully briefed on it. So if I may turn back to the scope, as the court knows, when the interpretation of a deed is reviewed de novo, and when the language of the deed is clear and unambiguous, we do not look towards any attendant circumstances. So we have a deed from 2004 that did declare two easements, easement 1 and easement 2. Easement 2 the deed is much more clear about how easement 2 might be limited, if at all. And what we have here is a description where easement 2 is specifically defined as a septic access easement, and the deed continues to say that there's a sole purpose for easement 2.
Who drafted the deed?
I believe that is not exactly in the record, Your Honor. I think there is some argument by the appellees that seems to suggest that the appellants had drafted the deed. However, that is not in the record at all. What we do know is that the appellee's predecessor in title is the one who granted that deed to the appellants. So
Ms.
if
Simon?
Apologize?
Was it Ms. Simon?
Yes, Ms. Simon. She changed her name to DARISSE, which is awfully similar to the DARISSE, the actual defendants, but no relation. I refer
Can
to
we
her as
just
Ms.
call
Simon.
her Simon? Yeah.
Yes, just for the purpose of clarity. She was the one in 2004 who had granted that deed. Both parties had attorneys at the time. There's no evidence in the record to answer the court's question.
Was she first approached by Henley?
I can't say for certain from my memory, Your Honor, if the record is extremely clear to that. What we do know is around 2003, and to the extent that I believe the record is complete on this issue, is that this was a new construction development. Parties had purchased the properties around the same time. The developer was building the properties. There was a pre-existing easement that benefited the Henley's property, to which Ms. Simon's property was servient, and that was easement I. And we refer to that as with lowercase I in our document as to differentiate from the Roman numeral 1 for the new deed. But the Henleys ran into a problem with getting a certificate of occupancy due to a problem with the septic. The easy solution, and I believe this is clear in the record, the easy solution would have been to use the pre-existing easement I and simply just backfill in some soil, grade it out a little bit, and that would have solved their problem. However, Ms. Simon's driveway was built straight through that pre-existing.
Right, no, we got it. I'm cutting you off, not to be mean, but because you only have 8 minutes, and I think you're going to want to use them. I promise
Thank
you,
you.
we know the story.
I understand, thank you. There was some approach, Your Honor. Who approached who? There was substantial negotiation that occurred over the next 10 months. That, of course, would be if the court finds that if the language is not clear and convincing and the court is looking towards the attendant circumstances to determine what was the intent of the parties in creating that. But our position is that the language is clear and unambiguous, and especially when we compare, just to expedite this argument, Your Honor, when we compare the language between easement 2 and easement 1, we see a clear distinction. And not only is there just a clear distinction.
So what is the distinction?
The distinction is that easement 2 specifically refers to it as a septic access easement, whereas the language for easement 1 simply says an access and grading easement without any limitation, without any qualifier or modifier.
And what do you think access means under the clear terms of that agreement?
Access means the ability to traverse and to enter. I don't think that the definition of access is so much being contested as to whether the access is limited for a specific purpose, such as with easement 2, where it says septic access, which would imply, of course, Your Honor, that access is limited only for that sole purpose. When we have easement 1 without that limitation, then it would be a general access easement for traversing through the property.
I will confess that I have some difficulty trying to read, this is maybe a broader problem than just this case, but trying to read the markings on the A&R plan. Is there somewhere better that I should look in the record to see a plan with the easements marked on it?
The A&R plan, Exhibit 3, I believe was reproduced also in the addendum to the reply brief, which might have a more clear version. We understand that due to compression to meet the filing, that there may have been some compression issues that may have impacted that. I would ask the court if that might be a more reasonable aspect, or sorry, more reasonable location. The conclusion, Your Honor, as to the general access scope is also buttresses by principles of grammatical construction, which applies to most instruments, contracts, land matters, things of that nature. I'm happy to move on to the next issue, unless the court has any further questions about the interpretation.
So you say access to do anything?
General access, yes. Now, if the court finds that the deed itself is not clear, then, and the court wishes to turn to the attendant circumstances, then we do know more about what the intent was. And we know that from Willis Henley's testimony in primary, which was that as the negotiations were proceeding between when they first decided that they needed to redo the easements and when the deed was actually drafted, they realized that in order to access the left or north side of their property, they needed to be able to go over this easement as well. And so,
just so I understand the framing of the issue itself, was the issue more for Henley's benefit?
No. The issue was primarily, of course there was going to be a benefit to the Henleys, so that way they could get a certificate of occupancy. But the primary benefit to completely reworking the old easement into the new easements was so that way Miss Simon would not lose her driveway. If the Henleys proceeded by right, they could have just dumped a ton of dirt. That would have completely cut off Miss Simon's driveway. They did not wish to do that to their neighbor.
Would it have just been her driveway or other neighbors in that area as well? I thought
just her driveway, Your Honor.
Okay.
And it was just by the pure location of the easement I that had been set by the developer, and then where the developer also decided to build Miss Simon's driveway. So that was
We
the
have some
only...
pictures of it in the record, right?
There's no pictures of the old pre-existing driveway. Oh, sorry, the driveway, yes, as it exists now, but not pictures of the driveway 2004, but I don't think that there is any material difference. The plans that are in the trial, sorry, in the record do show where the pre-existing easement I was located. It shows where the current easements are. That shows where the driveway is located, the property line, and so forth. Turning, if I may, to the court's finding that there was an implied easement, we suggest that that was error for two primary reasons. One is, in order for an implied easement to exist, it has to be both reasonably ascertainable and reasonably necessary. We're talking about underground utilities that cut for about 45 feet a swatch of land through the Henley's otherwise usable land. The evidence from 2004 is that there was no intent and no evidence to show that there was no intent of the parties to create such an implied easement, in part because they had no idea where the easements even were located. Contrary to other positions that I think might be presented, turn primarily to Exhibit 45, Trial Exhibit 45, which is joint stipulations of fact, and fact number 39 was a clear stipulation by both parties that no one knew where those underground utilities were located in 2004. There were no documents in the public record as part of this court record that says where the Henleys, that the Henleys knew where they were.
And that's, Ms. Simon's testimony is consistent with that, right?
believe Ms. Simon's testimony is consistent that she did not know. Ms. Simon's testimony leaves a lot to be desired. Most of her testimony consisted of answers to the effect that she doesn't recall or
Well, I think it leaves a lot to be desired for you. I think the other side's probably pretty content that they got what they needed, right? But be that as it may, she is the person who owned the DARISSE property at the time that these easements were entered into. And so if we're looking at the understanding of the parties about where the underground utilities were at the time of the easements, she's the person, and she's not, that's a question she did answer. So I don't hear you to be saying we can't rely on that answer, or she is, untruthful. I mean, the judge relied on that answer, and that's the truth for the purposes of the trial, right?
It is. We have made our arguments about why there might be clear error as to some of the judge's factual findings. But I think as to this particular issue, the evidence is uncontroverted that no one in 2004 knew the exact location.
And so that's all I'm trying to get at is, what is the legal principle, and I'm sure there is one, don't get me wrong, but under which the fact that they don't know is, I'm not going to ask this very well. I agree that it doesn't say anything in the language, the contract language about these utilities. It also seems evident to me on the record that nobody knew about the utilities. So what is the principle under which we say, well, you didn't talk about it, so too bad?
Well, I think that's just the test, Your Honor, for whether an implied easement exists in the first place. And it's generally a three-element test, but the third element does deal with reasonable ascertainability and reasonable necessity. So even if the parties knew about it in 2004, which we're not saying that they did, we still have to look at whether it's reasonably necessary for those utilities to remain in the exact place where they are right now in order to grant this implied easement. And the answer is no. The evidence in the trial record, and I see I'm very close to out of time, is that they could be moved for a reasonable sum of money and with very limited service interruption. And that altogether suggests no reasonable necessity, which therefore is no implied easement. I see I'm out of time. Thank you.
Good morning, Your Honors. May it please the Court. Tara Lynch for the appellees, Adam and Lauren DARISSE. Your Honors, all of the issues raised on appeal, we must look at the standard of review here, which is paramount. Most of these issues are reviewed for clear error. First, the Court's factual findings. They are integrally intertwined with the legal rulings. It's extremely difficult to parse out. This is a land court case. This isn't a contract where boilerplate's being interpreted again and again. The findings and the legal application of those findings is extremely specific to the parties, their knowledge, and the physical characteristics of the land, as well as the knowledge the parties had or were chargeable with at the time of the conveyances. The land court's rulings were not clearly erroneous. As Your Honor knows, those rulings or factual findings need to be paid considerable respect, and they need to be affirmed and upheld even if they're plausible in the record, even if this panel might have weighed the evidence and decided something differently. That same issue of clear error applies to the review of the implied easement. That's discussed in the Boudreaux case, specifically at footnote 4, which says the finding of an implied easement is reviewed for clear error. There was no clear error here. The test for whether an implied easement exists is what was the intent of the parties and is the intended use reasonably necessary? Now, my brother focuses specifically on the fact that there is a stipulated fact that the parties did not know the precise location of the electrical utilities at the time that easements were created. That is not dispositive. I'd point you to the Kittredge case cited in both briefs. An easement may be implied if we can fairly conclude that the grantor and grantee, had they considered the matter, would have wanted to create one. Ms. Simon testified at trial, and the land court credited the testimony. She said unequivocally, if part of the bargain of me transferring parcel B to the Henleys, which is over 1,000 square feet, this wasn't a little tiny plot of land. She got in return 17 square feet total.
She wouldn't have done it.
She wouldn't have done it. She simply wouldn't have done it, okay? And that's dispositive. That speaks to the intent element. You can go beyond that. The other cases, Mount Holyoke, Lavoie, talk about constructive knowledge, right? So although the parties might have not known the precise location, there was absolutely constructive knowledge that can be inferred here from the case law, the cases I just cited. Mr. Henley specifically testified, and the record confirms, that he watched the utility junction boxes go in on or about the property line circa 1999-2000. The evidence was also introduced into the record how the electric utilities were connected to the home around the same time. He also, testified that he noted that there were no overhead utility lines in the neighborhood. So all of those facts, the land court found there was constructive notice here. There can certainly be constructive notice that the utilities exist in the area. I'd encourage you to look at the A&R plan. There's nowhere else for them to go running from that junction box but through easement 1 and or parcel B. There's nowhere for them to go. So certainly constructive notice here. No clear error, and we would suggest that that particular finding of an implied easement be affirmed by the court. Now, if I may, I'd like to, before I move to the interpretation of the deed, discuss some foundational preservation and timeliness issues. First, the timeliness of the notice of appeal here I think is important, and it's an issue that the clerk identified and requested the appellant show cause on back in June of last year. The decision and judgment issued February 7th, 2025. Thereafter, my clients made some post-trial motions that resulted in the judgment being amended on March 4th. The amendment was clerical. It changed 2 references to count 4 in the judgment to count 2. That was all that was done. It was by agreement of the parties. Now, the Henleys filed their first notice of appeal prior to that amended judgment issuing on March 3rd. 10 days after the amended judgment issued, they renewed their notice of appeal to clarify that they were appealing from the renewed judgment. They concurrently made post-trial motions, including a 60B motion that resulted in, not the 60B, the 60A.
I think we understand. So there's another judgment to which they didn't appeal.
Correct. My point is simply that there is no notice of appeal filed after the April 17th decision, and I don't think that the case law cited by the appellant saves their case. Rule 4A3, as in effect last spring, states, and the case law interpreting same, that a notice of appeal filed too early is a nullity, period. And prejudice certainly follows to my clients who have, incurred the time, cost, and expense of briefing the appeal. Now, I'd like to then move to the issue of whether this question of whether easement 1 was ever a general access easement was preserved or asserted at all. The complaint speaks for itself. The complaint is verified by both plaintiffs. It incorporates numerous exhibits, and it includes numerous references to the Henleys seeking relief regarding really the surface rights in their easement 1 septic access and grading easement. They use those words. If I can direct your honor's attention just to a couple citations in the record, because I think that they're important. Specifically, the relief sought in count 1 of the complaint seeks a declaratory judgment that both easement 1 and easement 2 rights.
Where are you in the record?
Excuse me?
Where are you in the record?
I apologize. I'm reading from the verified complaint. The portions I'm reading for can be found at pages 55 through 59 of the record appendix. But the Henleys seek a declaration that they can use their septic easement, right, for the use at all times without prior notice for the maintenance, installation, and repair of 101 properties' septic system. That's the Henleys' language, not the appellant's. You could argue, certainly, Your Honors, that the Henleys got exactly what they requested in their verified complaint. They got a declaration that easement 1 is a septic easement and that they can access it without notice. That's really precisely what they requested, and it makes one wonder why we're here arguing that issue of scope on appeal. Now, if your honors would like to look to the plain language, the land court's ruling can also be upheld on a plain language interpretation. Your honors know that's reviewed de novo. And the language, in my view, could not be clearer. I think we agree that you can review the plain language. The appellants suggest, citing to the Moulton case for rules of construction, that the phrase, the modifying clause, and access thereto somehow creates a general access easement, but I think that ignores the rules of construction. I'm reading here from the 3rd paragraph of the deed, that's Exhibit 17. It's found at Record Appendix 5, page 162. The 3rd paragraph of the Simon deed with regard to easement 1 states, easement 1 is for the purpose of grading and regrading the grantee's septic easement area, comma, and access thereto, comma, in connection with the installation, repair, maintenance of the subsurface waste disposal system, surfacing and located on the grantee's lot. So what we have there, like Moulton discusses, is a modifying clause limited by the last antecedent, which is a reference to the grantee's septic easement area. But it goes beyond that. Moulton says that you don't need to limit the rule of construction in that manner if there is other evidence suggesting a broader intent in the exchange and the conveyances. We have that here. We also have language after the modifying clause referring to the septic area. So what we have here is the access language sandwiched by references to the septic easement. I don't think that there's any plain rule construction when you can find a general access easement based on that plain language. Now, of course, the land court, and this court may for purposes of completeness, look to the attendant circumstances if they think there's a lack of clarity in the deed. The attendant circumstances are compelling, and the land court's factual findings should be upheld in that regard. Just to direct your honors to a few key pieces of evidence that support the party's intent with regard to the purpose of easement 1, we have at Exhibit 54 and 55 letters from the Henleys written in 2003, contemporaneous with the discovery of the issue, speaking to town officials stating that they've come up with a solution to their Title V problem and they're going to work with their neighbor and get 2 new septic easements. Again, their language expressing their intent in 2003. We also have Ms. Simon testifying at trial that it was her intent to give the Henleys septic easements. She was having 1 septic easement extinguished and in exchange was giving septic easements back. The purpose was limited. Now, if I may move on to the issue of the surface rights that might exist within this easement 1. The Henleys suggest that the court sort of parse out that ruling. They do not challenge paragraph 4 of the amended judgment, which is the paragraph that gives the Henleys the right to keep that area fit for access for the septic purposes. They can pick up branches so that their septic pumper can come through and run a hose through it. That's fine. But they don't have, per paragraph 5, broad surface and landscaping rights. The court does reserve to the Darisses as the servient estate holder all reasonable uses that don't interfere with the intended use of the easement, here, septic purposes. So the court concluded, can the Darisses mow the lawn there? Yes, they can. They have a sprinkler system there. They put small handheld decorations, handheld flags and Halloween decorations. The court says all of that is okay, and it's correct interpretation under the law. I specifically refer you to the Texon case. That stands for the proposition that the servient estate holder maintains all rights that do not interfere with the dominant estate holder's specific easement rights. So again, the fact that the easement is clearly limited to septic purposes in turn informs the surface rights that come along with that easement under Texon. I also want to point out that the language regarding the maintenance obligations, it's also contained in that same paragraph 3 of the deed, The Land Corp pointed out, because that is the paragraph that limits by its plain language both easements to septic uses, of course if the surface rights or the maintenance rights are in turn going to be so limited. It's also interesting because the maintenance rights or obligations are tethered in the appeal only to the Henleys wanting to exercise broad surface rights in easement 1, but not easement 2. I think that's interesting because the maintenance obligations don't apply to one and not the other. They apply to both. Here, easement 2 is 95% covered with the DARISSE's driveway, and it was undisputed in the record that the Henleys aren't plowing the driveway, salting it, blacktopping it as needed. I see that I have several minutes left. Do your honors have any particular points to which you'd like me to respond?
Hearing none.
Thank you, your honors. I would otherwise rest on my brief. Thank you very much.
Thank you both. The matter stands submitted. Court's going to take a short recess.
Court, all rise.
Next matter on our docket is 25P0339, Karen BALCHUNAS and another versus Thomas FARDY.
Good morning, Your Honors. Patricia Gary for the appellant Thomas FARDY, and with me today is Dan Scapicchio, my colleague. Your Honors, in this case, it is our position that the trial judge committed 2 evidentiary errors which were a clear abuse of discretion and require reversal because they infected the trial. These evidentiary errors created extreme prejudice, resulting in the miscarriage of justice for Mr. FARDY. The first error was that the trial judge abused his discretion and violated the Wiretap Act, Chapter 272, Section 99C3, by admitting into evidence an audio recording that was intercepted.
And we have the audio recording, right? That's in our record.
You have that
We've
recording.
listened to that. It seems that you agree, at least per your brief, that the recording was made unbeknownst to anybody. Is that fair?
That's correct. It was secret, and for that reason, it was...
Well, not secret, but made unbeknownst to anybody, even,
True.
I don't want to call her Marissa, Miss Brown.
It was concealed, and for that reason...
Can I just to clarify, and I'm not to jump on Justice Desmond's question, but it was not done intentionally or willfully. You concede that?
Yes, so willful interception is an offense.
Okay.
The interception itself is not an offense.
No one argued it below, but I'm just curious. When she says, I've got the phone here, or whatever she said on there, and she's apparently just holding up the phone, what did your client think she was doing with it?
Well, it wasn't argued below, and there was a...
So you don't have to address it.
Yeah.
But it just seems to me that if we're saying that
Well,
he didn't know, it
You
kind
know,
of strange.
that's
but
definitely on the recording.
But your position is that the judge violated the wiretap statute, as did the attorneys to your right and as did the trial attorney
Yes.
for your client.
And I'm not saying that there's a right...
Well, what about your client's attorney? He also violated.
At that point, the tape had been played several times.
Does that make it any less of a violation?
But, well, it infected the trial, Your Honor. It infected the trial because the Wiretap Act is very clear, and it would be really an extreme just miscarriage of justice, and it would defeat the entire legislative intent and render...
Where in the statute does it say that even if there's a violation, or what case can you point to that says that even if there's a violation, there is a civil exclusionary rule?
I think a lot of the judges, Judge Wall, for example, the Superior Court judge that made his decisions both about impoundment and to deny the motion in limine to exclude the recording, he was using case law from the criminal context. And
Probation violation technically is civil. I know it's quasi.
This is civil, and a lot of
right, but a
confusion
probation violation,
stems-
which is one of the cases, is a civil proceeding,
It
technically.
really, there isn't a lot of civil law on this. This will be the case.
Let me try one more time, but the probation violation, which seems to be the case that was cited, a probation violation technically is a civil proceeding, not a criminal proceeding. Do you agree with that?
The case, are you talking about the Ennis case that the judge cited for his?
Yes.
No, that had to do with 3 people. One of them was incarcerated, recording, and it had there was an interception. The police weren't the ones.
I'm just asking what the nature of the proceeding, criminal versus civil.
Okay, so if you look at the structure of the Wiretap Act, which is what I'm asking the court to do, it's very well structured in that it has an introduction section, which has a preamble about the secret use of devices by private individuals, and that must be prohibited. So there is no real argument that private use is prohibited, just like it is in criminal.
I think what Justice Brennan is pushing back on, or one of the many things he's pushing back on, is the word secret. So do you think that something that is done unintentionally, I guess Justice Desmond asked this first, unintentionally so that it is unknown not only to the other party, but also to the party who is making the recording, is that the same as being secret in your
Yes.
view?
I think
Why?
that is answered by the SJC's recent case of Curatone versus Barstool. And in that case, the SJC talked about the term secretly, which modifies the words hear and record. It used Black's Law Dictionary to define the term secret, and it goes on for several pages to explain it. And it does say that if it's secret, it means that it was concealed. You know, it was
No,
concealed.
no,
so
but
that people didn't know
concealed,
about it.
so let's just use this sort of a less exalted example, right? Let's say that I have, I don't know, I have something in my house, like an earring, and I want to bring it to work, and I put it in my pocket. You could argue that I've concealed it, right? I knew that it was there, I took it, I put it in my pocket. Now, let's say that I had worn it 3 weeks ago and it bothered me and I took it off and I dropped it in my bag and I forgot about it. And 3 weeks later, I bring it to work and it's in my bag. Is that secret? Is it concealed?
Yes, the intention of the Wiretap Act, which is explained in Curatone versus Barstool, and I think that's where you're going to find your answer, is that the actor who is being recorded must consent to it as well.
Is it willful?
No, not necessarily. It's not, I don't think that, as it was described at trial, where Marissa Brown did not, or she contends that she didn't know that she was doing this.
And the judge credited that?
He credited that. And
So
we're not arguing that.
All right, so it's not a willful recording, and therefore, at least under 272-99C1, she did not violate
Well,
the
we're
wiretap statute,
You know,
right?
what we're talking about is C3, which...
No, I'm talking about, well, you may be talking about it, but I'm asking about one. I'm asking about,
No, we haven't alleged that one was violated.
all right, so she did not violate, and she was not the person
We're
who...
not arguing that C1 applies.
Okay.
We have never
All right.
argued.
And that would be the only one that would apply to her, right?
Well,
She didn't
that's correct,
disclose
'cause she
it.
did
You're
not-
saying that
she
the
did-
lawyer disclosed it, the judge disclosed it,
Right, and
the other attorney for your client disclosed
I
it?
think the answer to a lot of the questions, which is where in the Wiretap Act does it say that it cannot be admitted into a civil proceeding? And you have to look at the structure of the act, as I was trying to say before, and there is a section on offenses, which is C, and is followed, interestingly, by a section on exemptions.
Right.
And that's the section I'd
That's
really like
criminal,
the
right?
court
Because
to
if we look at
focus on.
civil, we look at civil remedies under 99Q, and under the civil end of it, it doesn't say exclusion.
No, but I'm talking about, this actually isn't in our brief, but I feel like there's a lot of confusion surrounding it. And if you look at the section D on exemptions, there's permitted interception of wire and oral communications, and there's A, B, C, D, E, F, and there's different permitted interceptions. And these are exemptions from the Wiretap Act.
I'm going to interrupt
If
you
you
for
go
a
to
sec. I'm going to
section
interrupt you for a
2
moment, because I don't believe that you argued that below. You argued that...
Well, that wasn't, we argued that it was an offense, but we're trying to explain why civil is different than criminal.
I understand.
And
but
I'm just pointing to the
remedy
act
for
itself.
Q, you pointed to Q, was it
Into the
Q?
act.
That might have been me.
Okay.
No, did you point, what section of 272 do you rely on?
At trial, and in the trial was, we argued that it could not be. We were saying it could not be disclosed. We were arguing because it hadn't been disclosed yet. This is a motion in limine.
I'm sorry, maybe my question wasn't very clear. What section of chapter do you rely on? Which section are you relying on?
So okay. At trial, there was a motion in limine, and that was what the judge denied. He denied our motion in limine to not allow this into evidence.
I'm asking you again, what section of the chapter?
So now we're saying that the violation was section C3, disclosure or use of wire or oral communications prohibited. And that has A and B. You're not allowed to willfully disclose the contents of any.
I think we've got that part of the statute. Let me ask you, you were the trial lawyer, right?
I was not there
Oh, I'm sorry.
personally.
There was someone else. So, but your client's trial attorney thought that the recording helped him because the plaintiff made threats to him, right?
Your Honor, the other side wanted to introduce this audio recording, not
For their
not my
purposes,
side.
yes. Well, no,
We-
but
we-
your side did,
Well, we made a motion to exclude it.
Yeah.
We tried very hard to exclude it. It wasn't excluded.
Okay.
And then it was played multiple times during the trial, so ultimately, trial counsel did play it just to get our side across.
let me ask you just maybe something that changed it up a little bit. Do you agree that there is appellate case law that says that notwithstanding a violation of the Wiretap Act, evidence under certain circumstances still may be admissible at trial, even where there is a violation?
In the criminal context, yes, and all of
Okay.
those cases, which are actually very few, focus on suppression. And suppression is not part of a civil proceeding. And I've been trying to
Right.
get to, I've really been trying to get to the part of the statute which says, under exemptions 2, which is permitted disclosure and use of intercepted wire or oral communication. So after the section that there is an offense by using or disclosing.
You haven't gotten there because you, I think, conceded that she did not actually violate the,
Not
statute.
Marissa Brown, but the judge did by allowing it into evidence, Your Honor. I mean, it doesn't do justice to the act.
so then
to
why didn't your
ignore
remedy,
this.
then your client's remedy to sue the judge? Which
Because
there's-
you can't do that. It's judicial immunity,
There you go.
quasi-judicial immunity, litigation
Right.
privilege. But that doesn't mean it can be, that doesn't mean it's fine to let it into evidence. I mean, is it? We're talking about a judge weighing what to do here and whether it is prejudicial, and it obviously is, and it really goes against the statute's intent.
So let's talk a little bit about
It
prejudice,
defeats the
okay? Because
statute's
let's, I'm
intent,
gonna
honestly.
assume for the moment that you're right.
Okay.
And that the judge was wrong. All right, and then we look to prejudice. And in this case, we have your client's plea or admission of sufficient facts that comes into evidence. We have testimony, we have medical records, we have photographs, which we can also discuss. And this, it seems to me, this recording, a few seconds, and it really wasn't terribly
It was played
informative.
it was played 4 times during the trial, and then the jury got to have a laptop in the jury deliberations room, which they
Right.
specifically asked for, and they could just keep playing it over and over again as many times as they wanted to. It's our position that it was extremely prejudicial. It
Are the
defeats.
jurors also liable for a violation?
So that's really, I think that we're missing the point, which is that it really just shouldn't have been introduced. And I really just want to focus back on the permitted disclosure and use of intercepted wire and oral communications, which is D2. And D2 has A, B, C, D, E, and these are how it's permitted. And it's all in the criminal context. It's all in criminal. It is not in civil. And by there's no civil allowance of it.
So-
That's really what it is. It is not allowed to be.
So let me just ask you this question. Where in your brief do you point to D2? Just point to the page
So
in
I
your
did
brief.
not do that in my brief because,
That's where it's important to point to
yeah,
it.
well,
Did you
I
argue
didn't.
it? Did you argue D2 to the judge? Where in the transcript can I find your
So
argument?
I think it's the context that we have to be conscious of, which is that there was a motion in limine, so it hadn't been admitted yet.
Did you argue it in the motion to eliminate? At the
In the motion
motion
in
to eliminate?
limine, the motion in limine just asked to exclude
Did
it.
you ever argue D2 anywhere in the course of these proceedings, other than right now?
No, but it's in the statute, Your Honor, so it's there.
understand.
It's in the statute. And I think I was reading a more recent case. I was reading the Ennis case over again because the judge cited it. The judge cited that. It was the only case that he cited in his.
Your time's running short. Can I ask you one question on your other issue, which is the photograph? I understand there was an objection before trial, for the record. When the photograph came into evidence, did your client object contemporaneous with the?
Yes.
Okay, can you point to that? I just couldn't find it because
Oh.
the record's a little tough. Where, what?
I know that it's in my brief, that I know that it's.
I didn't see a page and I didn't see
I can tell you where it is. It's in Record Appendix 4, page 399, and the objection, as I read it, was to authenticity. I do not see an objection to the admission of those photos on the basis that they were substantially more prejudicial than probative.
So that was another motion in limine as well, and we argue that that was a surprise because there were a lot of exhibits that were referenced, and those were what we responded to. And it was unfair surprise, honestly, to have that come in at the trial and say, here are these photographs. We know Judge Tutman issued a sanction, and we know that they're not allowed in at trial, but we're just going to try and get the judge to let them in. And we're not even going to put it in a motion in limine. We're just going to surprise everyone at trial.
And so when that happened, did you request a continuance? When the judge said, based on that surprise, I'm going to allow these photographs in, at that point, did you request a continuance?
I wasn't at trial. My side did not request a continuance. They objected to it.
I understand.
Very, very vigorously. And, Your Honor, I would also say that I think the judge abused his discretion by trying to provide excuses to the defendants, well, actually the appellees, and they were the plaintiffs, I'm sorry, that it was part of the criminal record. Like, he suggested that and was trying to give them that out. And that just wasn't the case. That was made up, and that's speculative.
You say it wasn't the case. Are you saying that the photographs had not been turned over?
No. Well, there's no evidence that they were. And
Let me ask you this question. Was the lawyer who did the civil trial, was that the same lawyer who represented Mr. Fardy at the change of plea?
I don't think so, Your Honor. From what I understand, it was a public defender, but I don't know that for sure. I've spoken to Mr. Fardy recently, and he told me it was a public defender. But beyond that, Your Honor, it was very unfair surprise to let those photographs in, because if we had known that they could come in, we might have been able to make a motion. We might have been able to try and authenticate them with metadata. There are just many things that could have been done.
Well, that's why I asked, did you request a continuance once you learned they were coming in?
I'm not understanding when you mean like of the trial, you mean a continuance of the trial.
Yes, that's where they came in.
I think that there was a lot of objections to it, and I don't know that the judge was going to, he said that they could be admitted. So I don't know that there was any way of getting around that, other than we're here today, appealing it.
We've asked you several questions. What would you like to tell us as I see your time's running out, or has run out?
I've talked about the structure of the wiretap app, which I wanted to add at oral argument because it wasn't in our brief. As far as the photographs are concerned, Your Honor, if a litigant can flagrantly violate discovery rules, have sanctions against them, and the sanction being you cannot have any of these any more documents admitted at a trial, and then they can get away with surprising the other side by just simply bringing them to trial.
It was on a list the week before trial. In the span of about 5 years, 6-year case, it wasn't. But in fairness, it was on the evidence list that was provided maybe 5 or 6 days before trial, right? Just so we're very...
It just should shock the conscience of the court.
Very specific on the record.
Your Honor. And we consider it to be an abuse of discretion and reversible error.
To say that they brought them for the first time to trial is maybe misleading, because the first time they brought them was to the deposition. Is that fair to say?
That's fair to say, but again, Judge Tutman issued a sanction. And when a judge issues a sanction like that, all counsel think it has to.
Are you saying a judge can't reconsider the sanction?
I'm sorry, Your Honor?
You're saying a judge can't reconsider a sanction if asked?
They can, but in this
And Judge Tutman, was she retired at this point? Do we know?
I don't know,
She may have
Your
been.
Honor. I just know that it was an unfair
They couldn't go back to
surprise.
Judge Tutman, in other words, not that they're going to find her 5 days before
The
trial.
excuse that the trial judge used, which is, you've had these now for 4 years, isn't really fair because we were relying on the sanction.
Is that an excuse or an actual ruling, if we're being fair to the trial judge?
It's the accumulation.
Just saying, I don't know that trial judges make excuses as opposed to actual decisions and rulings.
I guess he was
They had to make
trying
an
to
excuse.
coach them and give them reasons that it would be admissible, and his reasons were also wrong, you know, and it just doesn't seem fair. I mean, it doesn't give confidence in the judicial system if a sanction like that can be ignored on the day of trial and
So at bottom, it sounds like you're saying, just as a matter of fundamental fairness, it was inappropriate for him, it was an abuse of discretion.
It was an abuse of
for him to allow these photographs in the 11th hour.
Yes, Your Honor.
I see that's your time. Thank you.
Thank you.
Attorney Whalen?
Morning, Your Honors.
Morning.
Brooks Whalen, representing the plaintiffs. I'm with my associate, Anthony Gargano, and we were the trial attorneys in this case. Bearing in mind what the questions and responses were, I think I probably want to start with the recordings. The recording itself.
You know, Mr. Whalen, if you don't mind, just because since we're on the flow of that, can you explain why you waited until 5 days before trial to bring up the photos? Not that it's the most complicated issue in the world, but...
Well, I don't think we did.
Okay, why not?
I think that there was a hearing on the photographs before Judge Wald, and Judge Wald found as a matter of fact that they had access to the photographs in 2014.
So when you say that, he found that, did he say it and then find it? I didn't see in the,
I didn't see in the record
where you said.
To be fair, he questioned them about it, and they had no response. So what Judge Walz indicated was that in a reasonable criminal case, all of that discovery would have been turned over to the defense counsel.
But so what?
No, I understand that. So we go to 2000.
You try a fair amount of criminal cases. You're saying that...
Yes, I have, Your Honor.
Pull it up to the Lowell District Court that on a plea you're getting all the photos and everything before it?
And
I'm not saying they didn't, but I don't think it's a foregone conclusion by any stretch.
I understand that, Judge. And actually, I've been before you on a couple of them, I believe, as a result. But in 2017, they did get them at a deposition.
That was 2019.
No, was it 2019?
Yeah, July of 2019.
I'm sorry, you're right.
I didn't see anywhere in the record, and maybe it was in there, when they were complaining about the photographs and the late discovery, that you said, hey, we'd already given you these photographs. I didn't see anywhere in the record where that happened. So maybe if you could just point me to that, that would be helpful.
I think in the motion in limine, we mentioned the fact that they had been provided with photographs at the deposition, so they couldn't claim surprise.
Prior to the deposition. At the time of the time of the deposition, hadn't Judge Tutman already made her ruling?
I believe Judge Tutman had made that ruling.
Right, and the ruling was anything that had not been provided prior to this date is out, and that was before the deposition. And so bringing them to the deposition, they would have been excluded per Judge Tutman's record. I mean, that's why we're here.
Yes, and I think Judge Wall considered that, and he considered that to be, he considered the fact that they had received the photographs a year and a half prior to trial, maybe even 2 years prior to trial, so that they could not claim surprise. We also gave it to them, we also notified them prior to the trial that we were going to bring them in, and we showed them again. Having tried many cases with photographs, I just can't fathom the total surprise that is indicated by the appellants in this case.
Well, really? I mean, you can't fathom that they would be surprised that after a judge has specifically excluded certain testimony or certain evidence that it would be then used at trial?
No, that's not what I meant, Your Honor, and I apologize if that's the way I came over. What I'm saying is that yes, they can take a look at that, and yes, of course, they're before you legitimately on that issue, but for them to indicate that they have that it totally surprised them and that it threw off their ability to prepare their case. That I find
Well,
a
maybe
little
not
bit-
so much to prepare their case, but as a trial counsel, you know when you show up at trial what the evidence is most likely to be,
Yes,
particularly when you've had pretrial motions. So you know that this evidence has already been determined not to be coming in, and so you prepare accordingly.
yes.
And so that's why I ask, when on the 11th hour they're told this evidence is going to come in, was there a request for a continuance so they could now, knowing that this is going to come in, we can prepare accordingly? Oftentimes the question is, well, what would you have done differently if you had known the photos were coming in?
Right, and that would be where I would, something I also would indicate to the court. I don't think they would have done anything differently. I don't think that the appellant has indicated they would have done anything differently. I don't believe that the photographs were overly prejudicial. There certainly was testimony from the very beginning in depositions and obviously in the plea in 2014 that there was physical injury to Karen BALCHUNAS and that it was to her face, and she testified to that extensively at the depositions. So they can't be surprised by that particular issue, I think, to the point where it totally threw off their case. And if it did, they would have come before the court and said that. In fact, according, Justice Hershfang indicated, or their question for Justice Hershfang was there any, did they actually object at that point to the admission of those photographs? And the answer is no. They just went for authentication. And in the testimony of both parties, there was testimony about the injuries to Karen BALCHUNAS. So I don't see this as prejudicial to the point where it would overturn this case, considering the other elements of the case that went into evidence.
What about coupled with the recording? Can you turn to the recording?
I'm sorry, Your Honor.
Turn to the recording that came in.
Yes. As far as the recording is concerned, I guess we have to take a look at 272.99Q. 272.99 is basically a criminal statute. They are very particular. This is a statute that goes a couple of pages, and they are very, very particular about what's a criminal matter, how suppression is to be dealt with on the criminal side. And then they go to Q, and they specifically indicate what's happening under Q in a civil with a civil litigation. And they do not, as they do in the criminal side, indicate that the evidence, any evidence or any recording would be suppressed. What they say is that if you have a problem under Q, if it's a civil issue and a civil complaint, you have the right to go for damages. If you're damaged, you can sue for damages. They didn't do that. There is nothing in the counterclaim or the affirmative defenses by the appellant that says anything about that. So what the appellant is actually asking this court to do is legislate. They're saying, well, yeah, it's not in the statute, but you can make it in the statute. You can put it in the statute. You can make law today, Judge. That's what they're saying. And when I say judge, I mean Your Honors. I apologize for that. But that's in essence what they are asking you to do. Especially when the legislature was very specific about how 99Q was going to be handled.
Do you agree that there was a violation of 99C?
Absolutely not.
Why not? And that's not the willful recording by your client. They're pointing to the disclosure.
We're all committing crimes. If you played that recording today under their definition of 99C3, we would all be criminals.
So if I played it so my clerk could listen to it today,
According to the,
I would be liable under this statute, under their definition. That's a...
as I read the appellant's brief, you would be a criminal.
Not admitting anything, I'm just asking
No,
a
I
question.
understand that.
You said if.
I didn't listen to it.
But they have accused the judge, their own lawyers, us for committing a crime, a felony.
The remedy isn't to exclude it, though, is it?
No, not on the civil side.
For money damages.
Yes, completely. That's what the statute says.
Are you aware of any other circumstances, it's kind of a throwaway question, but where a law has been violated? I'm not saying you're conceding, because I know you don't, that your client violated the law, but assume for a moment that she had violated the law. Or let's say the police violate the law in a search and seizure. Are you aware of any circumstances where that is nevertheless admissible at either in a civil proceeding, I should say in a civil proceeding, where the evidence that was fruit
Unlawfully
of some
obtained?
illegal act?
Where the evidence that was unlawfully obtained by the
The evidence that is obtained as a result of an illegal act is still admissible in a civil proceeding. If you can't, it's okay. I just don't know if off the top of your head.
No, I'm thinking about it, Your Honor. I am not aware, but I am hesitant to say that it would not be
So, for
allowed.
example, an unlawfully seized piece of physical evidence that was suppressed in a criminal trial.
Gun.
Is there any case law that says in the civil proceeding that it needs to be excluded, or something that says something?
I'm not aware of any such exclusionary rule, Judge. I think that it would be allowed, because it would be part of the civil litigation. It would be material to the civil litigation. Just because it would be suppressed on the criminal side doesn't mean that it would be incapable of being introduced into evidence in civil litigation. There certainly could be instructions by the court about, this was not necessarily.
But not as a matter of law.
Not as a matter of law.
Exclusion as a matter of law in a civil case, right?
I'm not aware of anything like that.
Anything else you'd like to share with us?
On the issue of 99Q, I just don't think that and I stand by my brief on the issues of delay and standing as to 99Q. I do want to address the one issue about, because the appellants seem to spend some time on it. And this goes to the credibility of the defendant and what is prejudicial, overly prejudicial. Mr. Fardy took the stand and he testified. And he testified counter to his testimony at the plea. Now, there is law, and it's both federal and state law, I believe, that indicates that if you say something to a general plea, that's not really not conclusive. And we never introduced this as a conclusory thing. In other words, we didn't ask this court or the trial court for summary judgment on this issue, because it doesn't work as a summary judgment issue. The case law is clear. But the fact that he testified under oath and admitted to all of these crimes is introducible at the trial.
I don't know that he admitted to these crimes. He admitted that there were sufficient facts for which a jury could find him guilty. And he explained that he admitted so that as to avoid any period of incarceration, which is not uncommon. Oftentimes, folks will plead to a misdemeanor to avoid the exposure of a felony, whether they did it or not. But nevertheless, your point's well taken. When asked, did you hear those facts, and if those facts would occurred, he answered affirmatively.
Yes, and that was my point. And I think when you consider those questions and answers in relation to what happened and was testified at the civil trial, where he said, no, that's, well, First he testified completely opposite that under oath, and then.
I don't know how this is relevant to an issue on appeal.
Fair enough, then I will stop. If I'm not addressing something that the panel considers relevant, I'm not doing my job.
I mean, I suppose the only way I could see it, and we get 25 seconds, is if we do find error, was it prejudice, and is that part of the evidence that might, see here I'm doing what just
That was my
Judge
point.
Wall did, was just giving you the answer to the quiz.
That was actually my point, and perhaps I
think
was
that's what you were
going
saying.
around and around in circles around
Judge
it,
Wall, too.
and not making the point like I should have. But that was my point.
I see that your time, the matter stands submitted. Thank you.
Thank you very much, Your Honors.
Thank you both. The next matter is 25P0698, the Town of Westborough versus Northland TPLP LLC.
Good morning, Your Honors. Patrick Yerby for the appellant Northland. I'm joined by my colleague Ben Timon, and the General Counsel of Northland, Beth Kinsley, is here as well. The Land Court and all the parties agree that two decisions by the Housing Appeals Committee, one issued in 1992, one in 94, constitute the operative comprehensive permit for the Chapter 40B project at issue.
They do agree to that. Let me ask you this question from the outset. Do you agree, or do you think, that Ardmore controls this case?
Yes, I believe Ardmore requires that the comprehensive permit be enforced. So,
all right. So just to start there. Then, does Ardmore say that the town has to explicitly express their approval of the durational limit?
I believe that Ardmore says a few things. First,
Does it say that?
I believe that Ardmore it says that, first of all, the comprehensive permit must be enforced, and it also says that the town must express its agreement that affordability can be terminated.
And does it have to be explicit?
Explicit, sure.
You seem to argue, and maybe I'm mischaracterizing it, that it came up, and I don't dispute, that it came up during the ZBA hearings and during the HAC hearings, and repeatedly it was Northland's position that 15 years is going to be the time consistent with the subsidy, right? And there was no pushback to that anywhere in the record.
That is true. And I think really this boils down to those two HAC decisions are unambiguous, that this project would be subject to a lock-in period.
But is that explicit?
It is explicit in those two decisions. And
Where,
the town,
though, where? I mean, I suspect it's true that each of us has read footnote 1 a number of times. I think you'll agree that there's no mention in footnote 1 of 15 years or even of any specified number of years, right? So when you say it's explicit, I think you're going to have to give us a little more.
Sure, I'm happy to. I will say that our briefs break it down, our principal brief breaks it down step by step, but I'll take a stab at kind of summarizing it. So the 92 decision, which, by the way, the Land Court didn't say anything about, the language in the 92 decision. The 92 decision is essential for really understanding what footnote 1 in the 94 order means, because the 92 decision, first off, it just simply indicates that Chapter 40B projects are generally subject to a lock-in period. And it says that before an applicant can even apply to the zoning board, it needs to demonstrate fundability, that the project is fundable by a qualified subsidy program. The way the applicant demonstrates that is by getting a site approval letter from the subsidizing agency the 92 decision makes clear that that site approval letter provides the subsidizing agency's assurance that the lock-in period would have a sufficient duration. That's what the 92 decision says explicitly. And then it goes on, it elaborates and says that if a town disagrees that the lock-in period is long enough, then the town can challenge that to the Housing Appeals Committee or to Superior Court.
So you argue that the lack of the challenge is their agreement?
I don't think
I
that's
just want you
really.
to point to me explicitly where the town signs on.
The town explicitly signs on when it treated these two decisions as its comprehensive permit.
But is that explicit, or is that a reasonable takeaway from their conduct?
I believe so. There's, first off, not to belabor the point, Ardmore says the comprehensive permit must be enforced. The town never objected to any of the language in these two decisions. They accepted them. They treated.
Acquiescence by silence.
I would say one could look at it that way, but I think they did actively treat these decisions as the comprehensive permit. So it's a little more than acquiescence.
Are you arguing that somehow then that became incorporated into the agreement with the?
What we are saying is that
that is the agreement.
That is the agreement. The comprehensive permit, and this is what one should draw from Ardmore, is that the comprehensive permit embodies the town's agreement on the terms of the project. It has to. It's the town's permit. It embodies what's going to govern the project. That's the town's permit.
So is it telling then that, my word, when the town believed that the 15-year period had expired, they started to try to find placement for the folks who were going to be displaced. I think it was 22 units who were 24 units, I apologize, who were going to, got notices from Northland that, hey, we're going to market rate. The town then tried to find other housing for them, hired a housing consultant to try to help them find housing for them.
You're preaching to the choir, Your Honor. It absolutely is telling. It's telling. And the land court totally ignored all that evidence. There are all these communications by town officials that the town cannot dispute, that it understood at all times this was going to terminate. The way the town learned about Ardmore is telling. Because
the housing consultant.
As the housing consultant was hired to try to find subsidies, new subsidies to replace the expiring ones. That was all ignored by the land court. So we feel that we did not get a fair shake by the land court. We feel that the HAC decisions are, first of all, are unambiguous. The land court conducted no meaningful analysis of what they meant. Even if there were a question on what those two decisions mean, we don't think there is, but even if there were, the land court gave no meaningful analysis of all this evidence. It completely ignored the most compelling evidence. This was front and center during the trial. This was front and center in our briefing. The land court's decision doesn't even mention it. The land court—
I think the challenge is the language in Ardmore that talks about an expressed acknowledgement that, yes, we're signing on to 15 years.
Yes, I think that the land court just misunderstood that it's the HAC decisions are the express agreement.
But, I mean, I think the challenge for you, and I apologize because I feel like I'm saying the same thing again, is, you know, I agree with you. Those HAC decisions are they're actually very nicely written and they're comprehensive. They don't say anything in them about a term of years. I agree with you that they rely on, for example, the whatever cost estimates it was that were done that I think come into one of them but aren't cited, that show that it's, at a certain size over a certain number of years, it becomes adequately profitable. That's all part of the conversation. But if you look through the 92 and 94 decision, it never says 15. It never says term of years. All you have, and here I am really repeating myself, is footnote 1. And footnote 1's okay, but I wouldn't really call it a bang-up endorsement of the 15-year limit, right? It doesn't say 15. It doesn't even say, year. It just says, we are confident that the MHFA will ensure that 20% of the units are set aside for tenants with incomes no higher than 50%, that long-term affordability will be assured. Like, what's long-term? That could be forever, right?
It could be forever, but I do believe we have more than footnote 1. And we talked about at length what the 92 decision said. The bulk of the comprehensive permit here is actually the 92 decision. No one can dispute. It doesn't say a specific number of years, but it does say that long-term affordability would be that the affordability duration would be determined by the subsidy program. That's what footnote 1 means. And I don't believe there's anything in Ardmore that requires any kind of specific calendar date. It does use the word specify. Comprehensive permit must specify the duration of affordability. The HAC decisions do specify that. They say that affordability would last for the lock-in period. That's what the town agreed to. And again, if there were any question about that, well, let's see what the town intended. Let's look at the evidence. The land court never did that.
So I just searched the 92 decision for the word lock, and I didn't see it. What am I missing?
No, in the 92 decision, I'll find you the page, one moment.
It could be a technology problem.
I think it must be.
I freely confess that.
It might be a.
Could also be user error.
So on record appendix, page 94, second, or the
Yeah,
second
look
paragraph.
at that. I even highlighted it. You're right.
Yeah.
Okay.
And again, it says it a second time, and this to me is really the more telling statement here. On record appendix, page 95 into 96.
What volume? 1?
Volume 1, sorry. Volume 1, 95
Right.
to
For
page
instance,
96.
if MHFA were to create an affordable housing program with a very short lock-in period or a very low percentage of affordable housing, you don't have to stand up just because I'm talking, or excessive developer profit, a local board might appropriately question whether blah, 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 right?
Right. Why would a town ever want to challenge the duration of the lock-in period if it actually meant something? If this were supposed to extend in perpetuity no matter what, why would a town care what the lock-in period is? It's clear. This project is subject to a lock-in period, and the land court just got that wrong.
If we have to piece it together, is it expressed explicitly?
Yes. We provided authority that all the language, this is in the Whitaker case, a municipal permit should be interpreted like a statute or any other written instrument. All the language must be given meaning. The land court basically rendered footnote 1 meaningless and didn't even address all the language in the 92 decision. Well, I'm getting low on time. I think that really conveys our arguments. Maybe I'll just again reiterate, Ardmore requires these 2 decisions be enforced. I don't know how they can be interpreted in any way other than this project is subject to a lock-in period. But again, even if there were questions, at a minimum, we need to have the land court look at the evidence that its decision did not even address. Thank you very much.
Thank you.
Good morning, Your Honors. May it please the court, I'm George Pucci, and I represent the plaintiff town of Westborough. I think I said good morning. I lost track of time. It might be good afternoon. I was going to start with what was focused on by the defendant's counsel. He references 2 decisions by the Housing Appeals Committee. I agree 100%. There was never an actual permit issued. You would glean the conditions of the permit through those HAC decisions. neither of them explicitly state that there's an expiration date to the affordability restrictions on the permit.
But it is fair to say that throughout the process, there was some talk about the durational limit, and there was plenty of opportunity for the town or the town's acting authorities to push back, and they don't. In fact, and I'll ask you the same question I asked counsel, which is, why start trying to find homes for the folks who are about to be displaced? And why hire a housing consultant who says in passing, oh, by the way, there was this case that came out 2 years ago or a few years ago and talks about in perpetuity if it's not expressly in there. And then they see, well, that's our toehold, which makes me think they weren't thinking about that on the front end.
Your Honor, in the context of that is very important. So the permit had been issued many years before. You've got the existing project in the town. It doesn't comply with zoning. It's got the low-income housing restrictions on it. The town is just proceeding in good faith that this is one of the developments we have. This is what's reflected on the SHI, the subsidized housing inventory from the state, and we're going to continue going. And what happened was, it was basically, and this is why I say the context really matters here. And first of all, we're talking about not low and moderate income housing, we're talking about low income housing. So 50% AMI. So these are people that are facing homelessness. And
As for the emotion side, I get it. I mean, I understand the emotion side of it. I mean, who doesn't want affordable housing in their town and want to safeguard that? I appreciate that. But
right. The reason I bring...
protect it, and that seems to be on the town.
No, I'm with you. The only reason I bring up the equities about it, about real low-income housing, people that are either going to live on a sister's couch or face homelessness, is this was raised to the town. And the town is scrambling on behalf of these people that live in the unit, and in the units. They're going out, they're seeking, they're assuming at that point that the developer is in good faith, that the developer is right. The town isn't thinking about issues like this on a day-to-day basis. They have other town business.
Perhaps they should. I mean, that's their charge, right?
Well, that's not what Ardmore says. Ardmore doesn't say that a town is under an obligation to go, scrutinize all the permits that they have in the town and make sure that the SHI list is correct.
No.
When this issue got raised to the town, one of the select board members is on the Affordable Housing Trust, again, sought subsidies, trying to protect the people in the housing. He's not thinking lawsuit. He's not thinking they're full of it. This isn't consistent with what we thought. He's not thinking about it at all. He's just saying, we heard that they gave notice to these tenants. I've got to do something to protect these tenants. He went out and did it. One of the things he did was he hired the housing consultant. Housing consultant says, did the town know about this decision in 2002, Ardmore? Town looked into it, town council, it was then referred to town council, and town council's real estate from my firm gave the opinion Ardmore 100% applies. You don't have to be seeking subsidies. These affordability restrictions are in place in perpetuity unless you find that it was explicitly stated otherwise.
Why is the 92 decision not the agreement? Why is it not part of the explicit agreement?
The 92 decision is, Your Honor. I agree that the town is bound by what's in the 92 HAC decision overturning the zoning board.
Okay.
And also the 94 decision of the HAC approving the transfer of the permit. I was going to get to that part, but back to Your Honor's question, the context. So when they find out, then they take a different tack. They notify, and this is all in the record, they notify the developer that, no, we're not going to work with you about this. Under Ardmore, these restrictions are in place in perpetuity because it's not specified otherwise in the permit.
But they didn't believe that initially, right?
They didn't believe anything about it. They weren't thinking about it. And there's no evidence in the record of anybody from the town, ZBA, anybody from the town planner or otherwise, that shows that they were ever thinking about this issue. And it's like you finding out in your backyard that your neighbor owns, where the line goes through your kid's swing set or whatever, and you don't think about it until that happens. Then you look into it, you get a surveyor, and you find out. So the town is not under any assumption one way or another about what happens over the course of conduct over these years. I mean, defendants are pointing to all of this to say that there's somehow some type of intent requirement that was stated in Ardmore, but it isn't. Ardmore is a very straightforward holding that if it's not explicitly stated in the permit, and here you get the 92 decision and the 94 decision as the operative permit, then it's in perpetuity. So,
As between the town and Northland, whose responsibility is it to safeguard affordable housing in Westborough?
the way it works is when the permit is first issued, it's the subsidizing agency, because you have to be qualified. So you have to be a nonprofit and you have to have a qualified subsidizing agency. In the initial period, and often the subsidizing agency has these 15-year termination clauses. They are the monitoring agent in that time. And when I write a 40...
Are they acting in the shoes of the town?
They act in the shoes of the town.
Okay.
Well, more so on behalf of the tenant. You know, the system is such that it's really state oversight, state making sure that there's compliance with the 40B law. The way I do a permit is I will then have when that subsidizing agency agreement is up, I will have it transfer over to the town, that the town then serves as a monitoring agent to make sure if there's a conveyance, it's done in accordance with the affordability restrictions. So that's typically how it would work. So when the subsidizing agency is up, it's the town's responsibility to be the monitoring agent. And when I say responsibility, I mean if the town cares. Most towns do care a lot. They care about enforcing these affordability restrictions, and not necessarily out of the goodness of their heart. They want to maintain these on their subsidized housing inventory because then they can maintain safe harbor possibly under the statute. They're not subject to other projects. So when the town found out about Ardmore, they got the opinion. They notified Northland. The other thing that they did, which is quite extraordinary, that they went back to the state subsequently, actually, while this lawsuit was pending, and the state updated the shy list for the town. And so they corrected the previous error of an expiration date on the affordability restriction. They reissued it, and they said that it was in perpetuity. So the town's current shy list reflects this as in perpetuity. And I understand that's not binding on your honors, but it explains sort of the town's course of conduct here. When they find out, they look into it immediately, they find out about Ardmore, they enforce Ardmore, they follow up the state, and they get the shy corrected.
I understand, but that all seems to be, I don't want to say the tail wagging the dog, but it all seems to be kind of backtracking. What did Northland know? I mean, it almost sounds like Northland here is a wrongdoer, and I'm not sure why.
I'm going to be careful of what I say here, because I read a lot, and I read about private equity and what they do. And I'm not going to say anything about Northland, but what I will say about Northland is they took over this property in 2007. Ardmore was decided in 2002. They're a sophisticated entity. They're across the country. And again, private equity type firm. They looked into it. They knew about Ardmore when they acquired the property. So I'm not saying that they're a wrongdoer or anything like that, but what I will say is they had explicit notice that Ardmore was decided before they took this property over. And they made the investment decision to take over a property that had these low-income.
They're in the business of making money. That's what they do, right? I mean, I see all this in the brief about they own 26,000, I think you said, or somebody said 26,000 units across the country and made $1 billion. And
I'm not asking you to rule in favor of the plaintiff town because Northland is a wrongdoer. You asked me if I were to identify which one is in the right and which one is in the wrong, I would say it's Northland because they knew about Ardmore when they acquired the property. So even if it's a reasonable investment decision, they take the risk. The fact is they knew about it. It was decided before. And the law evolved, you know, on this issue about affordability restrictions because it comes up sometimes now because of the old projects that ZBAs weren't thinking at the time about expiration dates. Nowadays, I put right in the permit, this is enforceable in perpetuity, explicitly in the permit. So then, and getting away from the fact of wrongdoers,
So that would have been explicit, right?
That would
Had
be
we done that
explicit.
here, we wouldn't be here.
And so while we're talking about wrongdoers, we can assume Northland is not a wrongdoer, but the town certainly isn't a wrongdoer in it. And so that's my final point about Ardmore. I mean, the case couldn't be more explicit. I'm sorry, Your Honor.
I want to take you back to November 1, 1989. You may or may not remember it. That's the date on Exhibit 23, which is a letter from Adams, Harkness, and Hill, which is some sort of a firm, maybe it's an accounting firm, to the HAC. And this is the letter in which he says, whoops, I messed up my calculations for, the number of units and the lock-in period and what the IRR calculation is, right? So this is not addressed to the town specifically, though it is copied to a bunch of people that I'm guessing included town council. I don't know who these people are. Brian Pell, Frank Stemlock, and Richard Wood, Esquire. But anyway, this is the letter in which this person says, I prepared the IRR over the 15-year lock-in period for the affordable units, and then breaks it down in such a way that, at 274 units, it's this level. If you get down to 137, it's 2/3 of that, or maybe my math isn't good, but less anyway. It's obvious to me from this and from other contemporaneous records in the appendix that at the time that this petition, this request was before the ZBA and the HAC, this was very much part of the discussion. And by this, I mean the lock-in period. And as your brother pointed out, the 1992 decision mentions the lock-in period a couple times. In light of that, I agree with you that it does not explicitly say 15 years or in perpetuity. Neither of those things shows up. But why isn't that the backdrop that we need to take into consideration when we're thinking about what do these two decisions mean?
Yeah, drawing inferences from other circumstances is really not relevant under Ardmore. And what the operative permit, again, is the 92 decision and the 94 decision. The 92 decision, by the way, I'll point out, and Your Honor, if that doesn't answer your question, I apologize, but that's my best answer to it. Ardmore is very explicit. Ardmore says, where a comprehensive permit itself does not specify for how long housing units must remain below market, the Act requires an owner to maintain the units as affordable for as long as the housing is not in compliance with local zoning requirements, regardless of the terms of any attendant construction subsidy agreements. And that couldn't be more clear. 92 and 94 decisions, and by the way, the 92 decision, it is well written, and the person who wrote it ended up being the chair of the Housing Appeals Committee.
She's the same person who wrote the 94 decision, too, right?
Yeah, Warner Lowy he's been sort of the face of 40B for many years, and I have one left with him that he did after his retirement on Nantucket that we're waiting on his decision, but he's formally retired now as chair of the Housing Appeals Committee. But his order that he wrote, but the HAC order, has specific conclusion and order, and it gives conditions of a permit, and there is no period of an expiration of an affordability restriction in that. And you already pointed out the 94 decision, what does long-term affordability mean? And that also, in my brief time here, that goes also, what that footnote applied to is that this is qualified housing. It's a qualified subsidizing agency that we assume it is all above board, and yes, they are. And the last thing I'll point out is that's also in Ardmore. Ardmore addressed a very similar argument about, well, they incorporated the terms of what was in the subsidizing agreement, and Ardmore rejected that as well. So that would be the last thing that I would seek to leave you with. Thank you very much.
Thank you. Thank you both. Thank you all. Matter stands submitted. The final matter on our docket this morning is 24P 1264, Doe 528808 versus the Sex Offender Registry Board.
May I proceed?
You certainly may.
Good afternoon, Your Honors. Your Honors, I would like to focus my attention upon the second argument in my brief, that dealing with efficacy. I do so only because my sister has pointed out the several important points with regards to the first argument, that being that it probably should have been made by declaratory judgment. I was not the attorney of record at that time, so that wasn't done. Secondly, whether there is sufficient evidence to make an argument with regards to compulsiveness is also not something that I had any involvement with, and it's probably lacking, and the like. Secondly, with regards to factors 33 and 34, I do agree both that that issue was not raised at the Superior Court level, and secondly, there is some discrepancy with regards to the factual basis of support or otherwise, even though there was a report that referenced support and some stability in employment. At the time of the hearing, there was a lot of confusion that was going on. I'm sure you've read the transcript. There was some folks that weren't very happy, and some interruptions in communication, and whether or not the facts got properly presented. Be that as it may, we're left with the record that we have.
So all that's to say, excellent job
I told
on the
you that.
sideline.
Yeah.
Is all that to say we're waiving argument one?
No, I'm not waiving anything.
Okay.
You get to tell me.
I'm clear what you're telling me.
You and I have had enough history to know that you can tell me no. I mean, it'll happen in paper in a little while.
Can I, notwithstanding your gracious intro, I found the factor 2 argument kind of interesting, at least on a linguistic sort of common sense level, which is to say probably on a level that doesn't actually rise to being considered by us on this case, on these facts. But as I understood the argument, I thought you were saying, listen, compulsive means like you're compelled to do it, which sort of means you can't not do it, and here's 21 years of not doing it. Shouldn't that mean something? Was that your argument?
It was, except for the following. There's some holes in that argument that are about the size of this room. The first of which is that there was repetitive conduct that occurred during the actual governing offense. So that kind of takes away my argument with regard to compulsiveness. Secondly, there is a case, just since you asked, I'll tell you.
I did.
There is a case, Doe 526579, which says that 8 years elapsed between sexual assaults on victim 1 and beginning sexual assault 2 is not determinative. But there's also a reference that says, but Judge Milkey said in his concurring opinion in 22188 that the mere passage of time between offenses hardly demonstrates that such recidivism is compulsive. Now, here's where that argument takes us. 10 seconds. We all are now arguing, me being my sister and I and those of us on the respective sides, about whether or not once you exclude consideration of factor 2, based upon the lack of repetitiveness that meets the definition after 22188, whether or not the board could then consider compulsiveness. And the first decision that came out said yes, and then there's been a more recent decision that said, wait a minute, maybe we ought to see whether or not there's any evidence to support that, and in this particular case, the board didn't provide any evidence, and as such, we better send it back and let somebody else take a look at it. So I think it's an issue that's going to be ripe for all of us as we go along. Do I think it's present factually in my case, or is there sufficient support scholastically to say I can make that argument? No, but I'm not waiving it either. So let's go on to the next argument. Here's the interesting thing about this case. And again, I get these cases after somebody else has presented the hearing, somebody else has done here's what's interesting. When you start dealing with the efficacy, There's an old case that I cite in every one of these arguments, and nobody listens to me. Well, I shouldn't say that, but maybe they do. Be that as it may, that says basically we have to look at the access that an individual can have to a victim, and it's cited in my brief, so I don't need to go into any more detail. Hearing examiners routinely blow right by that, all right? That's usually in the context of an individual who has some physical limitations or otherwise. Now, I've tried to expand that argument in several of my briefs to say, well, what about probation conditions that say you can't have contact with an individual that's under the age of 16? So far, that hasn't held any water, but I keep trying. This case takes it one step further, and it takes one step further because of the following. Not only was there GPS, but there also, most importantly, were exclusion zones.
So
now,
let me just ask you though. So that makes him easy to perhaps get caught if he's committed the offense, but how does that somehow safeguard those potential victims?
I'm so glad that you asked me that, Judge. If I would have handled this case previously, and again, I say these things not to disrespect the attorneys below, but you know, sometimes when you have the benefit of a little more time, you can do things, and we're all very overwhelmed. I mean, nobody wants to do these cases, be that as it may. I found a 2015 study that was done in California that says, the name of the study is Monitoring High-Risk Sex Offenders with GPS Technology, okay? And an evaluation of California Supervision Program. What it says is that basically, I'll read you the first summary. A study of California high-risk sex offenders on parole found that those placed on GPS monitoring had significantly lower recidivism rates than those who received traditional supervision. That's the first important point. Then on the second page, it says, mandate the use of zones. The researchers argue that the use of zones may be the most important GPS tool because the application of zones allows parole officers to be alerted to specific offender movements. Now, just for, because I know you all know this, but just for my own satisfaction to represent it. Elmo systems, when you're on an exclusion zone, are a complete pain. And I've had many, many clients who have been on them. You walk by any school zone, it's going off. And it's not just an alert, it's an immediate notification to the police to go out and respond. So, there's even been some discussion in the cases that have followed out of this court, following the most recent case with regard, I shouldn't say the most recent case, but the case regarding the reasonableness.
The library case, was it?
What's that?
The library case? Was
No,
it that
no,
one?
well, the one that deals with the reasonableness of GPS in the first place. What's that? I can't, for some reason I lost it.
Can't remember that.
Be that as my sister cites it in her brief. That case said they've got to be reasonable, but there's been some decisions since then. There's been Arnold, there's been Rodriguez, and a few others, and what they start to look at is, okay, we have to look at duration. We have to also look at the existence of exclusion zones. We have to look at the degree of potential risk that the person presents, are they a level 1 versus a level 3? And at some point, maybe zones are too encompassing, but not to say that they shouldn't exist and not to say that they're not of benefit. And therefore,
is your point if somebody made a record of this, at least it's something that the examiner should have weighed? Is that what you're saying? Or?
Again, please?
No, are you saying that if someone had actually made a record of this, that it's something that the examiner at least should have weighed? And that,
well, yeah.
Or maybe I'm missing.
Well, basically what I'm trying to
fine.
say is
Let
that
me know what it is.
this would provide some evidence to say, if you have exclusive zones that have, the judge has gone so far as to say not only no contact, GPS, then exclusion zones. If this would have been introduced, it would have given some benefit or some argument or basis for an argument to say maybe the efficacy of active internet dissemination isn't warranted, because what I've read in the decisions, and I read more decisions on exclusion zones than I wanted to read of late, that basically say they work hand in hand. And certainly my sister's going to argue that they're more of a deterrent, but that's not necessarily all true, all right? Because especially when you have an individual like my guy who's never had a probation violation, It's going to be important to them. Here's one
Having
thing-
said that, Counsel, it's not part of the record, but in my prior life, if I could tell you how many violations of probations I did for
well,
people popping through exclusion zones and taking off the GPS.
Well, here's the one thing that doesn't make any sense, not to interrupt you, but the only thing that doesn't make any
The
sense
study
in
says
this
what the
case
study
is,
says.
you see a sentence. How many times do you see a sentence of 16 months, time served, with that number of convictions, and you put them on 5 years probation, and my years of criminal defense are long past? But what's the hook? Is there a hook? As I recall, you can't enhance sentence once you go back on a PV violation, so what are you going to do, get nothing? So that's the case, that's the factual part of my case that makes it difficult to make that argument here. But I think it's something that is going to be before the court, and maybe I don't have the basis factually today, and maybe I don't have the basis otherwise. But the final thing I will say is this. You can't just say nothing about it. And that's what this hearing examiner did. He mentions probation conditions under the dangerousness evaluation in one line. He's on probation. That's it. He makes no mention of probation whatsoever in the efficacy paragraph. I don't think that's the individualized, particularized evaluation of efficacy that 496501 is looking for. That's my argument.
Thank you.
This has been rare, Judge. I told my sister, I said, Judge Desmond and I usually have arguments. Yeah, I was, and we didn't get it today.
I think he's all argued out.
I thought that. I said, boy, we get to be last.
I will say it is always a pleasure. It is a pleasure.
Thanks, Judge.
Truly.
Thank you, Judge. Jessica Blackman on behalf of SORB. Counsel's argument isn't lost on me. However, I would indicate, or I would point you to the record and the specific facts of this case, which is what the hearing examiner was required to consider. And note that based on the specific facts of this case, exclusion zones really don't matter. They didn't come into play in these cases. If you look where this offender offended at, he was at home for the first 2 children that he sexually assaulted. And then...
So we'd have to GPS all the children.
Yeah, exactly.
But he does, I mean, I hear you on the exclusion zones, but I hear your brother to be making a broader argument, which is that the conditions of probation taken as a whole should have been considered. And there is a condition that bars this petitioner from contact with any child under the age of something, maybe 16, other than his own son.
It does.
And then, you know, I know that conditions are broken all the time. I'm not naive enough to think that just saying, I mean, I have children, saying don't do something doesn't always work. But how about that condition?
So the hearing examiner did consider his probation conditions and gave him mitigating credit under that factor. So when you compare, you know, he got mitigating credit for the fact that he's on supervision and has specific restrictions up through 2027, which is my other argument. These conditions are not permanent, they're only temporary. His requirement to register will long outlast the requirement that he's on a GPS. He, at this point in time, can petition the court to have that GPS removed today. At the latest, next year. So when that argument only stands as long as that GPS is on him, and then it's gone. The requirement of the hearing examiner was to consider the facts of this case at the time of the hearing, and based on that, determine his dangerousness and the need for internet dissemination and public availability. And at that time, he had the conditions and he was given mitigating credit for it. He only received 2 mitigating credit factors applied. There's 3 high-risk factors. Right there alone substantially puts this offender in a higher risk. And then there were another 10 risk-elevating factors. And I don't think there's any way that weighing those conditions any more than he did would have affected the need for his information to be out there. We have an offender who began offending as a child, basically. Yeah. Continued to offend into adulthood. He was 35 years old, the victim was 10. In both cases, he wasn't around a school. He was at home with his siblings being babysat by the girl that he assaulted the first time. And he was visiting a family friend who this child did not live with. So he wouldn't even have, it's not like it's a place where he would have known there was a child there. He went to a family friend's home and based on the opportunity and the fact that that child was there, sexually assaulted her as well. So I don't think those conditions would have, and the GPS would have any effect on the need for the public to still know that he's out there. He could find anybody at this point based on those facts that may have a grandchild or may babysit somebody or have somebody in their care that day. And those aren't going to stop him. The GPS isn't going to stop him from being around those types of people.
I took away from the argument that the position was that the hearing examiner didn't necessarily deal with the troublesome facts. It's not that what he talked about wasn't appropriate, it's what he didn't talk about.
Well, I think the hearing examiner, in finding that the active dissemination was necessary, I think his analysis was well within the discretion afforded to him and was explicit. He found that, I will just note, page 75 of the record, he sexually assaulted both the young prepubescent children as well as with a high level of physical contact. He demonstrated a very broad victim pool. The victims were known to him. Another empirically related fact that goes to increased risk of reoffense, he's been investigated, which if anything is going to deter this offender, you would think it would be 2 investigations and a prior charge, but it didn't. Another thing that substantially increases his risk to reoffend and the dangerousness when you look at how repeated sexual offenses, the harm caused to children, and these were all children. I think all of that combined, he noted all of these facts and everything that was before him and indicated that women and parents of young children, even teenage girls, should have access to this information in order to protect those children. I don't think that anything else is really required. He addressed the fact that he's under probation conditions. He has that GPS. He got mitigating credit for it. It's weighed into the risk and danger where required. Where those other 2 prongs were met, he clearly laid out the type of victim or the potential future victim that this offender and his victim pool consists of and why those types of people need to be protected. And I think everything within the record supported that, and he fulfilled all of his obligations based on the record. If you have any other questions, I'll rest on my brief.
Thank you so much.
Thank you.
Matter stands submitted. And that concludes our business for the day. The court is in recess. Thank you to the court officers and our time.